একটা সিডি হয়ে যাবে মেয়েটাকে থামালাম next week. I mean, we have taken so many matters. You come back next week. We'll
on corrections.
correction, yes, and
With zero. I take note, mention one matter. This is a matter of a bench comprising of your Lordship with Honorable Justice Uday Kumar. Here, your Lordship directed to conduct of an election.
hand over, Mr. Banerjee. If possible, if the file comes, we'll give it.
Only for extension of time.
Yes, it we bench bostely diye deben. Yes.
Your Lordship's pleasure to upgrade, take mentioning for upgradation.
What is the ground, Mr.
Lordship, my revocation order has been passed by the learned trial court, my lord, of a will which was probated. On the basis that a particular will, which was a subsequent will, was probated and that because that
we are generally refusing upgradation.
Lordship, I have
on more higher grounds we have
my
refused.
lord, I will come.
There is extreme compelling urgency. We are
my lord, compelling urgency is this, my lord, that on the 27th of this month, I have been directed personal appearance of the appellant has been directed along with the probate, which needs to be deposited before the learned trial court.
You just mentioned the pendency of the matters. That's not
Lordship, we have
more serious grounds we have refused because we can't upgrade.
My lord, may I renew my prayer next week, Lordship?
We can't assure that it will be allowed, but you can renew it.
Always beseeching your Lordship.
Mr. Trivedi, we may not allow it because we have refused on higher grounds. We are not being able to reach the regular matters. That's why.
My lord, kindly, my lord, I heard, my lord, there's some urgency. My lord, I'm praying for inclusion order 40. My lord, I was enjoying an interim order, my lord, of status quo.
Order for inclusion.
Yes, my lord.
Inclusion, please mention on Monday. I mean, we'll consider inclusion on Mondays.
Very well.
My lord, may I have my lord's leave, my lord? This again for upgradation. I leave it to my lords, my lord. This is a case where for 25 years, lordship, I'm not being able to enter my property. I have a decree from the civil court against the tenant.
We won't say wait a year more, but less than that.
My lord, but what has happened here is the plea of Thika tenancy under the 81 Act was taken, my lord.
To the merits of the matter with
My lord, the only thing is what has happened is under the 81 Act, they've approached the Thika controller. He's assumed jurisdiction and
strongly agreed, but I mean, don't jump the queue.
My lord, I'll take my chance again, my lord. Maybe
we are not permitting that, but you can do that. You have a right to. Yes.
Grateful, my lord.
I have the privilege to mention it's a land matter running under the heading hearing intra-court as item number 48.
Sir, you have heard us. We are not upgrading matters. Please wait for some time. We are not wanting to jump the queue. Others are waiting patiently. So let us wait.
How long can I wait?
Till it is reached.
Okay.
My lord, may I be permitted to mention one matter, my lord, for admission order 41, rule 11?
No, come back next week. You're telling others also. Yes.
Your lordship,
yes.
Just to refresh your lordship's memory,
yes.
The issue involved here is, my lord, there are quarters called CDLB quarters.
Yes, yes.
Those quarters are in a really bad shape. Well, DC asked us to demolish that. Well, we started the process of demolition. When
what is your answer to this Aadhaar card question?
That's I'm just to refresh your lordship.
No, now you remember.
Yes.
আর বই নেই?
No, মানে here.
অনলিতে একটাই আছে এই বইটা?
But may kindly take my another book.
কখন লাগবে না? Yes, Mr. Nag.
Now, my lord, the issue today is whether, my lord, the Aadhaar card can be treated as, my lord, a valid proof of identity. Now, my lord, lordship first will take, my lord, the statement and objects of the act. My lord, lordship will find an act to provide for good.
You are the union, Mr. Nag. You are for the Union of India.
No, I am for the
Port. Union is not represented separate.
Yes.
No, Mr. Shah cannot be for the union. Anyway, whatever, port is the main. Yes.
Now, my lord,
Mr. Nag, you have been this deleting names of people, and courts are holding that on the basis of Aadhaar Foreigners Act proceedings are initiated. So you are saying now that Aadhaar card is not a valid document of even title. It's being treated as a citizenship document by some of the authorities.
I am going to place the SIR judgment also.
Yes.
Just a quick, my lord.
So we are not on citizenship here actually.
No,
just on occupation. Just on occupation.
Just to prove, my lord, whether this can be treated as, my lord, a document whereby, my lord, the possession or the, my lord, residence proof. My lord, that is the issue.
Yes.
My lord, lordship sees, my lord, the act to provide a good governance, efficient, transparent, and targeted delivery of subsidized benefit and services.
Yes.
So that is the purpose. Now, my lord, again, Lordship will find the statement and object of the reason, the correct identification of targeted beneficiaries for delivery of various subsidies, benefits, service, grants, wages, and other social benefit schemes are funded by the Consolidated Fund of India has become a challenge for the government. The failure to establish identity of an individual has proved to be a major hindrances
With the,
for
but unfortunately, that statement of objection reasons is not there. Only the preamble of the act is here in this book. No difficulty. You are trying to find it out. It is not there in this book.
Really?
And, chapter, chapter.
Now, my lord, may I hand it over, my lord?
Yeah, no, you read it out. No difficulty. Acha. Thank you.
The statement and object and reason of the act.
Statement of object. Where is it? In this act? This book?
Lordship,
It's not there in this.
it's marked with pencil. এই বই দুটো দে না, বই দুটো আছে দুটো বই
এই বইটা আনিয়ে নেবেন তো প্রফেশনালের আধার কার্ড অ্যাক্ট professional. Yes, Mr. Nag, you better place from your book and we'll just hear you and we'll have this book brought from the our library. Yes, আনিয়ে নেন, হ্যাঁ, প্রফেশনালের আধার কার্ড অ্যাক্ট আমি বলে
No, my lord,
you read the relevant portion. Yes,
yes, my lord, the
you have
statement-
pencil marked up portion, you can also place
Yes. The correct identification of, well, first is the, well, targeted delivery subsidies of benefit and services. Then, well, in statement and object and reasons, the correct identification of targeted beneficiaries for delivery of various subsidies, benefits, service, grants, wages, and other social benefit schemes which are funded from the Consolidated Fund of India has become a challenge for the government. The failure to establish identity of an individual has proved to be a major hindrances for successful implementation of these programs. There is a grave concern for certain categories of persons such as women, children, senior citizen, person and disabilities, migrants, skilled and unorganized works, and nomadic tribes. In absence of credible system of authentic identity of the beneficiaries, it is difficult to ensure that the subsidies, benefit and services reach to the intended beneficiaries. So the purpose was, Malad, to give it to
targeted deliveries of
targeted delivery.
subsidies.
So it is not, when when the act was promulgated, it was never thought by the legislator that that will be proved as identity card. Now, Malad, how it is to be done, Malad, Lordship will find next, Malad, the definition. Malad, first I am placing 2C,
Yes.
2C of the definition.
Yes.
এটা তো বইতে হবে নাকি? Lordship, the Lordship will find that.
The act is there. No difficulty.
So
Yes.
2C, Malad, I am placing. Authentication. Authentication means the process by which Aadhaar number, along with demographic information or biometric information of an individual, is submitted to the central repository for its verification, and such verifies the correctness or lack thereof on the basis of information available with it. So, when the biometric information which is gathered is uploaded, they verify it, and they do the information. Now, my learned friend hopped on last occasion on K, 2K demographic information. Information includes information relating to the name, date of birth, address, and other relevant information of an individual as may be specified by regulation for the purpose of issuing an Aadhaar number, but shall not include race, religion, and
Yes. Yes.
so, this is the demographic information. Now, Lordship will take section 3. Every,
The address is also there in demographic,
Yeah.
that which was highlighted.
of course, but I will try to establish.
Yes.
Then, my intention before your Lordship is to prove that process of the Aadhaar card,
For the limited purpose of targeting
or
delivery.
not only that,
Hmm.
only one thing is verified, and that is the biometric information given at the time of enrollment.
Let's see that.
It is there. But other thing, there is indeed, there is no verification whatsoever. It's on the basis of declaration given. And
Come to, we understand. Please come to 3.3.
well, I will, my lord. On receipt.
You also target, make a targeted delivery of your arguments.
Yes, ma'am. On receipt of the demographic information and biometric.
Now, we are reading it, stressing on the wrong portions for you, so that you can answer. No.
Verifying information.
On receipt of the demographic information and etc., authority shall, after verifying the information, issue an Aadhaar number.
Now, manner, my lord, there.
Yes, in the manner.
Such a manner as may be specified in the regulation.
Yes.
Issue Aadhaar number to such individual. So it's valid in the the regulations, not here. Now, my lord, before going to into placing the regulations, my lord,
Yes.
I just want to place another 1-2 section, and then I will take your lordship.
Definitely, yes.
Now, my lord, lordship will find from section 34, because all the judgments I am going to place
On 34.
goes on this
Good. Yes.
34, penalty for impersonation at the time of enrollment. Whoever
Yes, whoever.
impersonates or attempts to impersonate another person, whether dead or alive, real or imaginary, by providing false demographic information or biometric information shall be punishable with imprisonment for a year. So, my lord, here, by providing, I'm stressing on the portion of this act, by providing false demographic information or biometric information. So, false demographic information is not something which cannot be given. Now, my lord, kindly come to the regulation which reads as the Aadhaar Enrollment Update Regulations 2016.
Yes. Yes.
My lord, it's a regulation. Lordship will
Got the
Now, my lord, kindly come to the authentication portion, which is at definition 2D. 2D is the authentication portion.
right. Yes.
Authentication means the process by which Aadhaar number along with demographic information or biometric information of an individual is submitted to the central identity data repository for its verification, and such repository verifies the correctness or lack thereof on the basis of information available with it. Now, let's pausing here for a moment. Well, the data collected are uploaded, and what the duty of the authentication process is, well, and such repository verifies correctness or lack thereof on the basis of information available with it. So, on the basis of information, they do that. Well, there is no physical verification of the demographic information. Now, my lord, I will go on to place before your lordship that here, my lord, name lordship will come to, my lord, 7. My lord, even the process of enrollment is not done. Even the process of enrollment is not done by the government authority. An agency appointed, they verifies it. Now, my lordship says, the registered appoints by authority shall carry out enrollment of individual seeking to enroll by themselves through enrolling agency contracted appointed by them. Then, my lord, kindly come to 4 of it. 7.4. Enrollment shall be carried out by the operators verifiers, supervisor, and other authorized personnel of the enrollment center. So the entire process is done by agency. Now, my lord, 10. An individual submission and verification of information. An individual who seeks to enroll shall be required to submit an application in form set out in Schedule 1, that I will show, shall present at the enrollment center in original, in verification, scanning one more documents, pausing here for a moment, and scanning one or more documents evidencing proof of identity, proof of address, where applicable, proof of date of birth or proof of relationship as both. Given his consent, then 2, a list of documents that may be presented to evidence the proofs referred to in sub-regulation 1 in Schedule 2, that I am also going to place. Then, my lord, collection of documents evidencing.
Give us half a second, Mr. Bhuna.
Now, my lord,
Including proof of address. That also includes proof of address.
yes. Now, my lord, proof of address, I will place the documents. Now, 4, verification of the information collected as part of the process of enrollment shall be done on the basis of documents Schedule 3. Now, my lord, kindly come to 11. The collection of information at enrollment center. So, how it is collected? Well, the demographic information, that is the issue basically. The demographic information as submitted by the individual seeking enrollment in the application set forth in this. So it has to be, this is a submission. So after that, whether there is verification, that is the issue. And my submission is, well, there is no verification of the demographic information. Now, my lordship kindly takes Schedule 1 and Schedule 2. Yeah, now, my lord, kindly come to Schedule 2.
Schedule 2 of the Act or the regulations?
Regulations, my lord. See, it's a list of acceptable documents for enrollment and update. It's a part of regulation.
Yes. Schedule 2, yes.
Now, my lord, Schedule 2, lordship will find list of documents in tabular statement. My lord, first it starts with list of documents that may be presented to evidence proof of identity, address, relationship of date of birth, such and such. Now, lordship will find here enrollment head of family. Head of family based of enrollment. So, my lord, here pausing here for a moment. If the head of family,
If it's an HUF.
if it's an
Oh, no,
HOF,
HOF, sorry. Head of family is referred to as
HOF. So, my lord, in case, my lord, I want to emphasize on that. If HOF goes and submits that this is the proof, and then, my lord, automatically the others comes into the enrollment, and there is even no submission of the documents. For, my lord, if it is based on the type of HOF. Now, my lord, enrollment type 2, documents based on enrollment. Now, my lord, is individual. Now, lordship will come here. List of documents to be noted below in tabular statement. Proof of identity document containing name and photograph. Now, my lordship, here there is a tick mark. Proof of address document containing name and address, tick mark. Proof of date of birth document, date of birth is not there. So, my lord, it is also, my lord, my submission here. It is done on the basis of submission again. Well, and in entire regulation, there is no role of the authentication agency to go there and personally verify that. So it is on the basis of I submit a document my lord, what is scrutinized is my biometric. That is there, and that cannot be challenged. Except that on the basis of submission, my lord, I can give a wrong proof of a copy of, my lord, photocopy of something, and that will be treated as my thing, my proof of demographic identity. Now, my lord, this issue.
But Mr. Nag, why are you stopping at Regulation 11 midway? Regulation 11, you placed one that is regarding the caption is collection of information at enrollment center.
Yes.
One says the operator shall capture, that is the collection of the information simpliciter.
Yes.
Two says upon presentation of one or more documents such and such,
The operator shall
yes,
make a copy of
come to B, small b,
give individual seeking enrollment to opportunity to check the agency of the information captured under, and copy of the same shall be
and shall after such checking upload such information.
online. This
So you
is
say the entire process is
online.
unilateral and they're on their side.
On their side and online also. The agency even not given the duty to go there and personally verify them and update the Aadhaar. Now, this issue, I am going to place before your lordship 3 judgments on the same issue. One by this court, one by Allahabad, and the Supreme Court. Now, the first judgment is not reported, is reported in live law. No, live law. No, I will start from this honorable court. I am handing over a copy to him. Now, this is the judgment. I first want to rely. Now, here, what happened, the one domestic help, impersonated and became the
Owner.
son of a deceased. The original heirs challenged the same, and the question came up before this court: what is the basis of issuance of Aadhaar, and to what extent it can be treated as identity?
You got this from your chamber or open a search? Yes.
Now, let kindly come. Paragraph 12. I am not placing the fact. Paragraph 12.
12. Right.
Finally, the petitioner approached the respondent number 2, the Unique Identification Authority of India, seeking action against the private respondent for offences committed under Chapter 7 of the Aadhaar Act, and even lodged a complaint with the respondent number 4, officer in charge, Kalighat Police Station, against the private respondent for committing cognizable offence and filing false evidence under India. However, no action was taken. Now, let kindly come to paragraph 14.
Yes.
In terms of observation in the order dated such and such, the question had arisen as to how income tax authority and other statutory authorities, including, could have recorded as the father of the private respondent any person merely on declaration of the private respondent, even though only had, as on death of said person, a married daughter. What I really wanted to know was where authorities of the respondent so gullible of the deficient technology to accept whatever has been stated by the individual regarding his demographic information as defined by the statute, or whether there was any procedure for verifying authentication of the same before recording part of process of enrollment. Same question, my lord, which is before your lordship. Now,
Para 15, very important.
The submission is recorded, and thereafter paragraph 7.
The SG says no authentication is made.
No authentication is. Well, paragraph 15, the learned additional Solicitor General submitted no authentication is made on material which is declared by an application for Aadhaar card. In his application, it is done merely on the details provided by the applicant in his application. He also submitted there if there is any discrepancy alleged or other mistake alleged under provision such and such for correction, the same other themselves and the writ petitioner may be relegated to such remedy. The learned advocate of the petitioner submits a penalty under such and such cannot be imposed as and when considered the disposal application such and such. Thereafter, Puttuswamy was considered. Considering that, kindly come to paragraph 19. The respondent number 2 before this court, the Unique Identification Authority, is a statutory body under section 11 of the such and such act, which came into force from such and such. The UDI is mandated to issue 12-digit unique identification number called Aadhaar to the residents based on demographic and biometric information submitted by them to the UDI at the time of their enrollment of Aadhaar scheme. These Aadhaar numbers were communicated to the respective holders physical from or via later postal communication. The system came I am not placing that. Paragraph 21. However,
21,
the
yes.
issue seeks judicial determination before this court that no one which pertains violation of fundamental right to privacy because leakage of such and such the undertaking sharing of the information and other apprehension which the petitioner before the Supreme Court were concerned. Rather, the question have been raised against very sanctity of an Aadhaar card as a source of individual identification. Therefore, to begin with a disclaimer, must put into effect that Aadhaar is not only means for identification and question of the identification of the person based on civil dispute would be decided, do not solely less with the Aadhaar in identification. So this is the portion, Malad, that is important. Then Malad, Lordship kindly takes Malad. Now 24, a bare perusal of Aadhaar Act makes it patently clear that an individual seeking to register with the Aadhaar scheme has to part with 4 types of information collected from making Aadhaar application complete. Mandatory demographic information comprising name, date of birth, address, such and such. Optional demographic information, non-core biometric information comprising photograph, core biometric information comprising fingerprint. Then the biometric information of the individual is the individual's physical, that is to say, biological particulars which cannot be sent by someone. His retinal scan, fingerprints must be provided by him personally by being present before the authorized person of the authority who records the biometric information after the individual has made the application before the respondent number 2. However, these are information which can be physically verified, are in fact physical. Demographic information such as name, date of birth, address, other relevant information on the application requires something more to be verified and something more than mere declaration. Now this portion is important, Malad, I just placed. Now Malad, kindly come to 2K has been referred. Then Malad 27, it is under the head the information concerning parentage of the individual is sought. It become clear. Aadhaar enrollment regulations September 12 issued under such and such rule 10 aforesaid lays down guidelines for submission of verification that shall be provided aforesaid. Thus, it becomes necessary to understand the verification process in accordance with the above schedule for the reason Schedule 3 before is set out. Then, Malad, Lordship will find address details in the chart. Lordship will find any proof of address, any of the proof of address documents, introducer, HOA, family, or people who have no documents. So it is also given to them. Then, Malad,
Yes.
28, the demographic information under the parent, guardian, and the field's father, mother are shown to be Schedule 3, but optional case regulation, there is no verification required to be done in the case of adults for father, husband, or guardian, which means whatever an application says his father's name, the respondent is gullible to accept this as gospel truth. Then, Malad 29, it is not doubted the entire system of Aadhaar has been structured in a way to ensure that there is no leakage information resulting violation of constitutional right of privacy of the citizen of whom information. However, there has not been enough deliberation upon the other aspect of the system concerning demographic information, namely as to what happens when such information taken turns out to be false. So, after that, Malad, Lordship will find paragraph 32. This definition lays down both demographic, biometric, establish the identity of the Aadhaar card holder, therefore information collected for the individual, even false demographic information to pass under the scanner of the Aadhaar authority without their being sufficiently verified. In other words, I think it is arbitrary to allow one sort of information, establish the identity of an individual to pass without verification while subjecting another sort of information, stringent security, though both are voluntarily submitted by the applicant. Such attitude on the part of the respondent towards important identity information of an individual is sure to frustrate, if not hold, at least a substantial objective of the Aadhaar scheme. If such practice are allowed to pass, unremarked under judicial scanner, it will be diluting the credibility of an Aadhaar card as far as demographic information printed out in the corrected portion. So, my lord, this is the judgment, and then, my lord, so my lord, it says, my lord, that it helps, my lord, also paragraph 38, where, my lord, again the submission of the learned additional solicitor general has been said that no verification is sought. Now, the judgment of Allahabad division bench is also, my lord, very important here. My lord, here what happened, my lord, there was repeated incident of child marriage. And, my lord, when
Yes.
set of case went before the division bench of the Allahabad High Court, Allahabad High Court found that the date of birth that has been given an Aadhaar card as a only proof. So they are getting away with this. So, my lord, they were summoned. The Aadhaar authority was summoned. And after summoning them, my lord, this judgment was passed. My lord, kindly takes, my lord, I am skipping the fact, my lord. My lord, paragraph 14. It is in this context, my lord, paragraph 14 first.
14, yes.
Well, the issue is, my lord, here first, it is in this context, in the interest of justice, we asked UIDI clarify the issue while framing the question of what facts Aadhaar card is proof. So this was the issue. Then, my lord, order was passed and Aadhaar authority was summoned. Now, my lord, paragraph 18.
Yes.
We hereby record.
This is important.
Yes, 18.
Yes, read it.
We hereby record Ms. Jasmine, Deputy Director of UIDI Regional Office, Lucknow, appeared in the court repeatedly to assist the court to clarify the issue, which frequently arises. We appreciate the effort.
The appreciation is binding on us.
Not really, but that the authority came and deposed.
Yes, yes, that you're saying, yes.
We need to make a detailed reference.
They filed affidavits also.
Yes, they also filed.
Right.
Then, my lord, the
affidavits are more important because the person may not know the law,
yes,
but the affidavit they are bound.
Affidavit was filed and everything
Yes.
was clarified.
Full-fledged.
And also, my lord, we could not file the judgment. Paragraph 19, Lordship will file.
Yes.
We need to make a detailed reference of the contents of the affidavits filed on behalf of. Suffice to say, essentially, UIDI relied on 01 relevant excerpts for the judgments rendered on by such and such. But we could not find it, but it is a Supreme Court judgment that has been taken into account before laying down the law in this judgment.
Para 20B is very important.
Yes. Pertinent to gist of this case, biometric information received is matched with the UDI relies on the name, address, date derived from the proof of identity, proof of address documents as submitted during the enrollment. UIDI takes no responsibility with respect to correctness of name, date of birth, or address of the person.
Yes.
So this is the main issue, and thereafter, my lord, Lordship will find there are. Well, kindly see after D, after subparagraph D, well, it's a repetition that is not taken. However, there is a fundamental difference between Aadhaar card as a means of identity and other documents, though which identity can be established. Enrollment of Aadhaar card also requires giving biometric demographic information analysis. The process eliminates any chance of duplication. Then, my lord, whenever skipping one paragraph, there would be a second attempt to enrolling for Aadhaar for this purpose gives his biometric, it would be immediately get matched with the same biometric information already. So this is the process. So I am issuing subsidy. So there is no two, same citizen cannot claim again. Now, the important portion is paragraph 23 after the discussion.
Yes, yes.
From the paragraph 21 is also important. I'm thankful.
Yes.
My junior, paragraph 2 affidavit, Ms. Jasmine, the deponent, has clarified if a resident does not have any valid supporting date of birth document, date of birth is recorded on the basis of declared approximate date of birth. In case of approximate date of birth, age is verbally communicated by the resident to the operator and the ECIM calculates the year of birth by default. Consequently, even the date of birth, even without document, it is done. Number 22. Mrs. Jasmine has further clarified in paragraph 3 of the affidavit dated such and such, Aadhaar is only a proof of the fact the person who is trying to obtain subsidy service by identifying himself on the basis of Aadhaar number is the same person who had enrolled for Aadhaar after providing his biometrics and other documents at the time of enrollment. Aadhaar is only a method of identification of identity that Aadhaar holder preserved himself at the time of enrollment. From the above, we can safely deduce, firstly, Aadhaar card is a document providing conclusive connection between photograph of the Aadhaar holder, his fingerprints, his iris scan details with the Aadhaar number. Secondly, we clearly deduce from the above the other information, namely date of birth, gender, address as entered is furnished by the Aadhaar applicant at the time of authentication of the enrollment. 25. Although regulation provide for the application to rely on a set of documents for giving information in regard to name, address, proof of birth, however, because of the said information is merely given by the applicant, it is not authenticated by UIDAI at the time of authentication. The Aadhaar card cannot be conclusive proof in regard to it. Thus follows, case of dispute regarding correctness of date of birth, burden of proof lies with the resident applicant of the Aadhaar card. From the above 27, from the above conclusion, it is the stand demonstrated that in a case of person relies on the entries regarding address, date of birth on the basis of Aadhaar card under Evidence Act, it cannot be said that the entries in those regards are conclusive proof of those facts. If the question in this regards arises, the source of giving date of birth required to be verified in the process of investigation. Now, my lord, this question again came up. Oh, my lord, the Supreme Court in recent, my lord, the SIR judgment. Lordship knows, well, everyone knows what happened, but here the issue was, well, whether the Aadhaar card can be treated to demonstrate that he is a valid resident of a person and his name should be included or not. It's not specifically on the issue that the other two judgments said, but I just want to place, even the Supreme Court said that it is not it cannot be treated as that document on the basis of that his name will be even in the electoral process. So, my lord, here I am just, this is a big judgment. I am just going to place before your lordship only the relevant paragraph and nothing else. My lord, first is 10.8.
Yes.
In the interregnum, the instant batch of writ petition came to be filed. Upon hearing the parties, this court, while issuing notice to the commission, observed that the prima facie appraisal, three substantial questions arise for determination. First, the very authority commission to embark upon the impugned exercise. Second, procedural methodology adopted in carrying out exercise, including the method prescribed by the commission ascertaining citizenship of the voter. And third, the propriety of the timing given at the elections of such and such. The court further observes that in the interest of justice, obviate and any unwarranted exclusion of eligible voters should, in addition to the 11 documents, also consider accepting Aadhaar card such and such as valid proof. Now, you say SIR, it can be considered as additional thing. Then 10.13, the issue arose consideration concerned the legal acceptability of the Aadhaar card as a supporting document in the SIR process. The court observed, in terms of the Aadhaar, an Aadhaar does not constitute proof of citizenship and therefore cannot be relied for the purpose. At the time, it is noted, section representative of People's Act includes Aadhaar among other documents which may be produced for limited purpose, identity of a person. So, my lord, it's only, my lord, treated as identity of a person, and 2-3 paragraphs more. Kindly come to, my lord, paragraph 98. For instance, insofar as documentation regime was concerned, the initial grievance of the petitioner entered around the exclusion of widely held Aadhaar cards. The concern was directly addressed by this court while directing inclusion of Aadhaar so as a valid document establishing again identity, the intervention such and such. Then, my lord, and another two paragraphs. 148, my lord, if lordship kindly takes.
Yes.
Addressing the exclusion of specific documents, the commission submits the same is founded on a valid and rational consideration, that is, insofar as Aadhaar card is concerned, reliance was placed on section 9, which does not recognize this as proof of citizenship domicile, thereby rendering it unsuitable for the purpose of electoral verification. With the respect of ration card, it was contended value compromise due to instance of large scale irregularities and forgery as regards to
Those are regarding ration card and NAPIC. So Aadhaar card does not recognize proof of citizenship or domicile.
domicile. Nothing.
Domicile is important for you because the
Yes,
residence
domicile
is connected with that.
Now, my lord, just two paragraphs and I conclude, my lord.
Yes.
156.
Yes.
Now, my lord, again it is reiterated the same portion. Insofar as exclusion, the justification, the statutory framework, Aadhaar card does not treat as proof of citizenship domicile is an exercise where the commission is required to be satisfied as to eligibility in terms of statute. Now, my lord, 157 is important. It is, however, pertinent to know, may not constitute proof of citizenship or such and such. RP Act, it used limited purpose for establishing identity of its recognition. Statutory code directed the commission to treat Aadhaar card additional 12 documents for identity. Considering the process of inclusion, exclusion stated, it was, however, made equally clear such recognition does not elevate Aadhaar to conclusive proof. So, my submission here, the first two judgment was on the issue, and it is also relevant. Why? Well, if the Aadhaar card does not even say that, see, on the basis of Aadhaar card, I treat you as the voter of that.
It can at best be a proof of the identity of the person because the biometrics
biometric is
cannot lie.
Biometric
Cannot lie because your fingerprints and all that.
Yes, so
But nothing else.
Nothing else. Well, two judgments on the point, and the Supreme Court judgment I place. Well, if even the Election Commission does not believe, and as upheld by the Supreme Court, that the Aadhaar card is not recognized recognize the citizen, even
citizenship is on a higher ground, but domicile is also
domicile.
So domicile is connected with residence.
Correct. So it does not even say that this person is situating there and that area he is eligible to vote. Here, now coming back to the case, here there are 52 petitioners. Out of 52, only 22 says they have Aadhaar card in respect of the respective address. In respect of 30, is not even, the Aadhaar card is not even showing that they are the resident of CDLB area. Now, here, the law is well settled. I have to initiate. The main contention is that in the name of demolition, I am evicting them. My contention, I am demolishing for the safety of the human being staying there, or so that the life is not in danger. Now, here the question is therefore is, if their case is that I have to initiate an act under 1971. So for that, section, the Unauthorized Occupant Act, the occupation has to be proved. And occupation means, lordship knows, but is settled occupation whereby from other documents and everything will come. He is the person, he is residing there. Here the question is, except Aadhaar card, in spite of option given by the court, he failed to produce any other documents and stick to that stand. No, I have Aadhaar. So the Aadhaar is my proof of occupation. So, if on the basis of the Act, regulations, two judgments which are specific, it says that it's not a proof. It's it's on your own volition you given this, and there is. So, I think, they should not come under the permit of 1971. And when considering the urgency of the matter, the process of demolition should go on the premises, because the letter of DC is very clear. It's not me at my instant I'm saying, the authority is saying do this.
Yes, yes.
Authority is saying do this.
Achha, regarding it being dangerous condition and all,
My lord, I have,
how do you know that?
my lord,
Before the writ court, did you produce anything?
no, my lord. My lord, there is a report submitted with the code below that I have, it is at page 118, the report I have submitted where the photograph shows it is in dilapidated condition. That has been done
118 of this their application.
118. That was handed over at the time of argument. And my lord, this is a comprehensive report. Independent, my lord, there are photographs lordship will find here in this report, although the report is of 2023, lordship will find at 128 the situation of the building. 124 onwards, the photographs are there. Lordship will find the situation of the building there. Because this is basically deserted building by the CDLB employees. Now they are going there and some are staying there. Now, my lord, one other thing, the letter of the DC, which is very important. My lord, lordship, which is at 134. 134.
Yes.
Respected sir, kindly, well, later date, my lord, will find, my lord, May 2025. After that, we have started the process slowly. Well, because I have to also appoint agency to chairman Kolkata Port Trust. Respected sir, kindly find the enclosed letter OC Westport Police Station regarding dilapidated 502 residential at Brooklyn, which are imminent risk of collapse at any time, posing serious threat to public, threat to life and property. Immediate intervention is required to prevent from any potential disaster. And in the rainy season, the danger, my lord, escalates, my lord. Therefore, your concerns sanction kindly requested to take tangible solution in this regard. Officer such and such, such and such. So, like, basically, OC, my lord, the next page, basically, officer in charge of the Westport PS, first time, not the first, I can't say, my lord. He first time pointed the issue, prayer for requesting Kolkata and KMC authority to take urgent steps to prevent collapse of CDLB quarters and such and such. This is to bring to your kind notice the extremely unsafe and deteriorating condition of CDLB quarters located at Brooklyn, Garden Ridge, such and such falls within jurisdiction Westport. The premises 32 four-story building block comprising such and such. These structures originally under ownership of such and such, now occupied by nearly 8,000 residents. Over time, due to complete lack of maintenance, structural repair, the buildings have become dangerously dilapidated and imminent risk of collapse, posing a serious stress to life and property. This concern already has been brought up to the notice of Kolkata Municipal Corporation and CS Limited for inspection. It is also understood discussions are ongoing between DFA, KMC Authority, Kolkata Port Trust regarding the issue. Still, no tangible solution has been taken yet. With the onset monsoon season and growing threat of severe cyclic condition, the risk of structural collapse has increased. In view of that grave situation, immediately intervention is essential to prevent any potential disaster. In view of the matter, it's earnestly prayed that the Kolkata Port Trust KMC be urgently approached to take proud.
Now we are asking you two questions. These are appear to be technical, but because if it's really dilapidated, you understand the urgency. Two things. One is that neither the police nor the port authorities are the appropriate body to conduct a demolition. There is no KMC notice in view.
KMC.
No KMC notice till now. Secondly, police admits that it's occupied by 8,000 residents. Have you given a notice to single resident?
No, I tell you. Well, 80,000 residents are not there.
Use the mic. Don't be so surreptitious.
8,000 residents are not there at present. Because most of
some
the
residents are there.
No, most of the
First one notice to any resident.
Most of residents have gone.
This is entirely your submission from the bar.
No.
The documents which were before the report.
I tell you, Lordship, some of the
order was passed on in June only. This
some of the building has also demolished. Also demolished. Only these few they are saying that I am not going to leave.
Demolished. They themselves fell.
No. We appointed agency. We did miking. We did miking. I have the proof. I can produce that. We did miking. We did issue no.
Miking is not a notice under any.
No, and post is
Miking, you
I
coming to demolish, I demolish.
I tell you, Lordship, if they are like occupants, some are coming, they are going out. Nobody knows about anything about this.
That's being developed by you, Mr. Nag, on instruction, not by you. Your instruction is developing it. But we don't find anything on record. Any KMC notice, one notice.
Notice was pasted on the outer wall. I am told. I can produce that.
Was it? It was not.
Not under the act. Not under the act of 1971. Because my stand is clear. They are not occupant. They cannot prove their occupation. It's like migrant workers coming, residing there for 5 nights and then going out. But how can I trace and issue notice to everyone? And it's not a drive for eviction also. Kindly mind it. Here
drive for demolition. Not eviction, demolition.
Yes, because
better than eviction. Demolish, there is no question of eviction. You evict whom? It's razed to the ground.
Today, before your Lordship, there are.
So you have a very good point in it.
There are 52. I tell you, Lordship.
They can't prove their occupation, which is also held by the learned single judge.
Yes.
And we are sitting in intra-court appeal. We are aware of that.
Lordship. So,
the first court.
They has to prove, this 52 that I have.
Yes.
Occupation. Now, out of 52 from the cost title, 22.
So let us focus on the 22. 22 also you have this argument on the Aadhaar card, these judgments and all.
But they are also
30 in any event. If they don't have Aadhaar card, then
they will go.
The picture
they will go. Now, in case of 22 also, the Aadhaar card is not the conclusive proof.
Not conclusive. Yes.
So they then
doing your arguments regarding those 22 for the timing. 30, if they don't have anything, then they go.
And 22 even, on the basis of 2 judgments of this court and the Allahabad division bench, which makes it clear that cannot be proof of identity. Proof of address. That cannot be the proof of address. I can say anything and do anything. So on the basis of that, the option was given to them. It's not that the option was not given. In the order, Lordship will find 15th order. Kindly have a look at 15th.
So they were given opportunity.
Opportunity was given. Supplementary affidavit file.
Yes. We have seen that.
Lordship, grateful.
That's not a question of they are not getting any opportunity. You might not have got opportunity. That question did not arise for filing your opposition.
Yes.
That stage did not come.
Because they, in my humble submission, they could not even prove a prima facie case.
Could not cross the threshold.
So that is why that is rejected. I am grateful.
Yes.
May I correct Mr. Nag on some facts, subject to correction? First of all, Millard, repeatedly it was pointed out to your Lordship that the addresses which are there in the cost title, the addresses doesn't match with the billing quarters. Now,
yes.
Millard, may kindly come, Millard, there are total 31 buildings. Millard, this includes the CDLB quarters and the CPT quarters. CDLB full form is Millard, Calcutta Dock Labour Board quarters, and CPT is Calcutta Port Trust quarters. Now, Millard, they are carrying on a demolition drive on all these quarters. And that is my pleading before the writ court. If your Lordship kindly comes. If your Lordship kindly comes to from page number 28, this is my writ petition. And if your Lordship kindly comes to page number 20, page number 56, Millard, of the stay application, Millard, that is the prayers in my writ. Prayers before the writ court.
Yes.
Prayer B.
Yes.
Issue a writ in the nature of mandamus, quashing the entire process of demolition as undertaken by the respondent authorities upon residential quarters, dwelling units and structures named as Calcutta Dock Labour Board quarters, CDLB, and Calcutta Port Trust quarters, located at Brooklyn, Garden Reach, Kolkata, declaring the same as manifestly illegal, arbitrary, and excess undertaking in the grave violation of natural justice of the petitioners. So, Millard, there are 2 kinds of quarters, CDLB and CPT. So, Millard, the addresses that has been pointed out for Lordship, that this is out of the ambit of the writ petition, it is not. CPT is in the ambit of the writ petition, and that is my pleading, that is my prayer. First. Secondly, Millard, a submission has been made before your Lordship that only 22 people have produced Aadhaar cards before your Lordship, before the writ court, and rest 30 people have not produced anything. Millard, with due respect to Mr. Nag, Millard, the submission is manifestly wrong. Why? My lord, because 52 of them, serial wise, has produced documents before the writ court. And in fact, my lord, if your lordship, for example, my lord, if your lordship kindly comes to page number 74 of my stay application, which is part of the writ petition before the writ court, my lord.
Yes.
My lord, this is a gas bill, my lord, that has been produced. My lord, may kindly see the consumer address, 453, 4th floor, block 3, Brook Lane, Kolkata, West Bengal, India. So, my lord, Brook
In your
Lane is-
initial arguments, you only addressed us on other cards, as if all have produced other
No, my
cards.
lord, because
And now we find new document.
no, my lord, why I will tell you, lordship, my lord, the
The
initial
gas bill is a valid proof. They did not get an opportunity to argue on this because
No,
you did
my lord,
not take this
my lord,
one.
my lord, may I, my lord, my lord,
This person has not given other card.
So
Some
this
have
person-
given other.
some have given gas bills, whatever that was available at that point of time. Because Milord may kindly understand the situation, Milord. At that time, there was a demolition drive going on, and they were coming up with whatever documents.
No, you got an opportunity to file supplementary affidavit. You cannot say that at that point.
Milord, supplementary
If
affidavit.
you have it at your home, you can produce it the next day.
Supplementary affidavit. But the learned judge pointed out us that whatever the what authority do you have, you point out, and
Yes.
where are you reciting, you point out. Only
Exactly.
on these 2 points.
So
Only on these 2
for that, you had the opportunity to produce documents, whatever you have. Not that you were in a breakneck hurry and you could produce only this. You are given an opportunity to produce. That is the reason the learned.
Now, Milord, there were some documents. Now, Milord, the learned single judge at that point of time,
So
only
all did not produce other cards. That is his submission. That is correct.
all
Some produce other documents.
some produce other documents, but they have not produced any documents. That is not the correct submission. Milord. 52 of them have produced documents. 52 of them has documents in the writ petition.
So how many are, what other documents?
Milord,
22 have produced other cards.
other
What about the other
cards
30?
and gas bills.
Voter cards also.
Voter cards also. Voter cards are also there.
So you did not make this argument that you argued only on other cards.
No, Milord, because Milord, the writ court has only noticed other cards. Writ court has not noticed anything else, Milord. I'm not for that reason, Milord. I have the copy of the writ petition with me also. Milord, if anyone disbelieves, Milord, I have the copy of the writ petition that is with me, Milord.
That's annexed here.
It's annexed, but I have my copy also, Milord.
Why should you be disbelieved?
Milord, that is the thing.
Unless you do something justifying that disbelief.
So, Milord, that is the thing, Milord. So, all of them have prima facie produced some documents, Milord. So, Milord, this is the first limb of my submission, Milord. Secondly, Milord, before going to the Aadhaar card argument,
Yes.
Public Princess Act. Now, Milord, for even demolishing a construction, Milord, subject to obviously, Milord, I find that my locus has to be proved first, but still, Milord, for demolishing an unauthorized construction, Milord, even if I go with the gas bill and even if I appear for that one petitioner before a lordship, even if for demolishing the unauthorized construction, they has to obtain an order from the estate officer. Without that, they cannot demolish, Milord. If it is on because, Milord, my petition is pointed out on demolition. So, Milord, even if I appear for that gas bill individual before your lordship and proving locus of for that gas bill individual and taking locus from that gas bill individual, if I point out before your lordship, Milord, may kindly comes
So
to
section 4.
section 5A.
Section 4 also comes in. Just look at section 4 also. 1971 Act. Public premises unauthorized.
No, section 4 is for eviction, Milord.
West Bengal na.
Public premises.
Public premises.
Yes.
Public
আচ্ছা,
premises.
ছিল তো আর কি।
I have 2 copies.
নিন ওনার কাছ থেকে। রাখুন ওগুলো নিন। There are certain judgments which say first they have to say that you are in unauthorized occupation.
Yes, Milord. Milord, that was one of the judgments that I have referred before the learned read court, Milord. That judgment was also not considered, Milord. I will be coming to that.
1 minute.
That was by Justice Nijjar and Justice Banerjee, Milord.
1 minute. You did not cite it during your regular arguments. Now in reply, how can you cite this?
Milord, that was considered by the read court. So that is there in the.
They were arguing on this. For the first time in reply, we cannot permit you to cite a judgment.
Milord, that was considered by the read court. That is mentioned in the read judgment. Milord, section 4, if your lordship kindly comes to me. Milord, this is for eviction. Milord, issue of notice to show cause against order of eviction. If the estate officer has information that any person is in unauthorized occupation of any public premises and that he should be evicted, the estate officer shall issue in the manner hereinafter provided a notice in writing within 7 working days from the date of receipt of the information regarding the unauthorized occupation calling upon the person.
So therefore, two
concerned.
notices are contemplated. One is under 1, subsection 1. Estate officer shall issue, once they decide they'll evict you, issue a notice in writing calling upon you to show cause as to why it should not be made. Then if estate officer knows or has reasons to believe that any person is in unauthorized occupation, that finding has to be there, that satisfaction has to be recorded, then 1A
And
under
estate
1A,
officer can order
another
give a
notice.
summary order.
Then which follows, which is followed by 5.
5. Now, my lord, eviction. 5 is eviction of unauthorized occupation. Now, my lord, from there was an amendment in 1980, my lord.
5A remove
5A,
unauthorized.
power of to remove unauthorized occupation. No person shall erect or raise any building or any movable or immovable structure or feast, display or spread any goods, bring or keep any cattle. Now, my lord, subclause 2, my lord, where any building or or other immovable structure or fixture has been created, placed or raised or on any public premises in contravention of the provisions of subsection 1, the estate officer may serve upon the person erecting such building or other structure or fixture a notice requiring him either to remove or to show cause why he shall not remove the premises. Now, my lord, this is with regard to if I raise the construction. Now, 5B is with regard to the construction that is already there. Order of demolition of unauthorized construction, my lord, 5B. Where the erection of any building or execution of any work has been commenced or is being carried on or has been completed on any public premises by way of grant or any other mode of transfer, and such erection of building or execution of work is in contravention of or not authorized by such authority, then the estate officer may, in addition to any other action that may be taken under this act or in accordance with the terms of the authority aforesaid, make an order for reasons to be recorded therein directing that such erection of work shall be demolished by the persons whose at whose instance the erection or work has been commenced or is being carried on or has been
So
completed.
you are on the proviso.
Provided that no order under this subsection shall be made unless a person concerned has been given by means of notice. Given by means of notice, served in the prescribed manner, reasonable opportunity to show cause why such order should not be made. Now, my lord, 5C is power to seal unauthorized constructions.
That stage has not come.
So, my lord, there was no sealing, there was the demolition directly carried on. So, my lord, demolition cannot be carried on without any order, my lord. My lord, my main argument before your lordship is.
Why did you establish the foundational fact of your possession?
Now, my lord, occupation, my lord, I will come to that, my lord. Now, my lord, my argument is that the port trust do not have any unilateral authority to go and demolish any building, even if it is because they are statutory authorities, my lord. They are statutory authorities, they are statutory landlords. Now, my lord, they cannot go and demolish any of the buildings. They have to have an order from any competent authority to demolish the building, or even if a notice at least, my lord. Now, my lord, in this case, there is, my lord, I find now first time before the appeal court, my lord, that they have affixed a notice, my lord, but my categoric argument before the read court was that there was no notice served upon us. I still stick on that stand, my lord. Now, my lord, I first time find that there was a notice affixed, my lord, but I do not agree with that, my lord. Now, my lord, before dealing with these judgments, my lord, now, my lord, with regard to the verification of the Aadhaar thing, my lord. Now, my lord, it is admitted fact, my lord, whatever from the judgment, my lord, that whatever documents I give, on the basis of that documents, the demographic informations are verified, right? And what I have understood, my lord, on the basis of that demographic information are verified, and there was no physical information. Now, my lord, taking that to be correct also, my lord, the documents which are prima facie required for the proof of possession of a person, that documents are submitted before the other authority, and on basis of that, the other, it is not that without any document, other authority issues an ID card. The documents which are to be produced.
So, our specific question was, argument was, first, it is not a conclusive proof of any of the other details than your biometrics. No physical verification is made.
No
These are the two
verification is
primary points. So, actually, whether you're in occupation of that, which is important for invocation of 1971 Act, that is not, the Aadhaar card is not a conclusive proof of that. Not a conclusive proof of anything else than your biometrics, your identity. You may not reside there, but have the biometrics and you may be identified as the correct person, but not reside. Address, it's not a conclusive address proof. And there is no physical verification also as provided in the regulations. So how do we know that you are actually in occupation?
Now, my lord, physical verification is not there. Now, my lord, but the documents which Mr. Nag referred before your lordship in the regulations, the documents that need to be submitted for verifying the address for the documents, that documents are important for physical verification. The documents which have to be submitted to the Aadhaar authority for correlating with my address, my lord. So that documents, after verifying that documents only the Aadhaar Act, the Aadhaar card is issued. First. Secondly, my lord, the Aadhaar card which has been if Aadhaar card doesn't comes under the conclusive proof of possession, my lord, the gas bills and all comes, my lord. Secondly, and thirdly, my lord,
We don't understand the secondly.
my lord, the gas, my lord, it was not only the Aadhaar card that was produced, my lord. That is the thing. But the
The Aadhaar card is not that gas bill is all the more not a proof. Aadhaar card still some process of semblance of a verification is there. Gas bill, what verification is there? You may not have any gas cylinder at your home at all, but you may have a gas bill. If you pay, you will get a gas bill.
But my lord, the documents
It's entirely unilateral.
but my lord, the documents which are produced by the Aadhaar authority, after verifying those documents, there is no physical verification.
But the judgment says it's not conclusive after considering those documents.
No, my lord, we kindly remember, my lord, the last day, my lord, it is a rebuttable proof. It is a rebuttable proof, but they will have to rebut.
It's not a conclusive proof of your evidence, of your position. Then where is the question of rebuttal?
Now, my lord, if I impersonate my details, my lord, there is a procedure under the Act.
That's under a different criteria. Identity is something else.
No, my lord, if I impersonate as someone that I reside on that address, then there should be some proceeding, my lord.
Penalty, yes.
My lord, one of the even any proceedings has been drawn against one of the persons, my lord.
That's a different question. Other authorities might not have initiated a proceeding, but still it's your burden to prove that you conclusively prove that you are residing there. Conclusively does not mean as conclusive as a civil court. Not in that sense. Conclusive means it's not conclusive at all. Conclusively, not necessarily the prima facie is not necessarily the opposite of conclusive. Conclusive may be at various stages. Conclusive may be even to raise a presumption. Like marriage registration documents, conclusive proof, those line of judgments and provisions. Now it's conclusive proof, conclusive in the sense it creates a presumption of correctness, official act. But how far it is conclusive, for what it is conclusive, that is also to be considered. So for presumptive value also, there has to be some amount of conclusivity to a document. That it conclusively proves it. Every conclusive document is also rebuttable before a civil court, suppose. Everything is rebuttable.
But that has to be.
There is nothing which is not rebuttable.
But the powers of the civil court are vested with the estate officer. Now, powers of a estate. Now,
that is what we are saying. That
without a estate proceeding, my lord.
But it is not even conclusive means that it does not raise a presumption at all.
Now, my lord.
Their argument.
Now, my lord, kindly come
the
to the judgment that has been referred to then, my lord. Paragraph number 35 of these Devashish Nandi judgment.
Yes. বইগুলো আনিয়ে নিচ্ছেন ওই দুটো দেখি একবার ফেরত দিই দাঁড়ান এটা আর এটা আধার এটা পাবলিক প্রেমিসেস এটা আনিয়েছেন এটা আমাদের না এটা ওদের দর্শককে দিন সরি ইয়েস
Before proceeding further, may I request your lordship?
Yes.
Before proceeding further, may I request your lordship, subject to your lordship's indulgence, my lord, may I come back with better arguments, my lord?
Every day will be a better day, no difficulty. We cannot, on that ground, it cannot be. You complete your arguments.
My lord, paragraph number 35 of the Devashish Nandi judgment.
Because the moment you seek that, you will also pray for an extension of the interim order. That's why we are saying conclude your argument.
No, my lord, if your lordship gives me tomorrow also, then
tomorrow, do we take up these matters? Do you sit in division bench? You don't know that.
Lord, paragraph number 35, my lord.
Yes.
Against this backdrop, this court finds it necessary to refer to certain queries posed by the petitioners in SG, Wombat, Kiran, and another versus Union of India, and the responses of the UIDI on the same. These questions and answers are referred to in Justice Case Puttaswamy and others, being a petition number so has been called out and stated as the following. Now, this was the union's answer. Now, please confirm that no UIDAI officially verifies the correctness of documents offered at the stage of enrolling updating. Now, the answer is as per UIDAI process, the verification of the documents is entrusted to the registrar. For verification based on documents, the verifier present at the enrollment center will verify the documents. Registrar enrollment agency must appoint personnel for verification of documents. Normally, the documents which are submitted before the Aadhaar authority, those documents
Documents are verified.
but those documents are prime office position documents. That is my submission, because the regulation specifies the documents that needs to be submitted. That includes the PAN card also, the date, the birth certificate also.
So you say that those are at least conclusive proof of your prima facie proof of your position, even if not conclusive.
Even if not conclusive. Now, my lord, even if my lord, I have some prima facie proof, my lord. Even if I have some prima facie proof, my lord, of position, my lord, I cannot be condemned unheard, my lord. That is my submission, my lord. No person can be condemned unheard, my lord. This is a case where
Yes.
now, my lord, kindly comes to for once, my lord, the schedule 2, which my learned friend has referred to, my lord, learned senior friend has referred to, sorry, my lord.
Yes.
Schedule 2, my lord. But I'm thankful for your lordship for the tag, my lord.
For
the tag, my lord, I could.
But we cannot thank you for that because you have taken our tag and you are detagged. We'll have to find it out now.
No, my lord, this is schedule 2, my lord. I will find out, my lord. My lord,
No. Schedule 2 is the
Schedule 2 is the, my lord, of the Aadhaar enrollment and update regulation. The documents which are to be produced for obtaining Aadhaar card.
one. Thank you. Yes. Got it. Yes, Mr. Banerjee.
My lord, to the schedule 2, my lord, there is a note, my lord. If your lordship kindly see. Any document, my lord, a note is there, my lord. After the chart, my lord.
Schedule 2.
Yes, my lord, schedule 2, there is a note, my lord, there.
That is schedule 1.
No, my lord, in my book it is schedule 2, my lord. After that, there is a note. Huh? No, page number milve na. Page number milve na.
Give that book to us once.
এই বইয়ের 130
আপনি এদিকে আসুন আপনি বলুন এই বইটা ফেলে দিতে Yes.
But there is a note, my lord.
Note is there, yes. Any document listed.
Any document listed in the above tabular statement shall be accepted only if
আনে কিনে আনিয়ে আনাতে বলুন।
এই তো এটা একটা আর এটা একটা এটা দিয়ে থাক।
Yes, we have to. There.
my lord, I will have to refer
আপনি
to
ইয়ে বলুন এখনই কিনে আনিয়ে
ওটা দেখো।
যেন আমাদের কোর্টে পাঠিয়ে দিন।
ওই যে এটা তো কমার্শিয়াল
হ্যাঁ হ্যাঁ কমার্শিয়ালে আছে আচ্ছা আচ্ছা আচ্ছা
Commercial also contains it, yes.
130 sir 130 130 130
What page of that?
but commercial
Professional which
দ্যাটস
page?
নট না না
Professional আচ্ছা দিয়ে দিন।
সেম
there is a note, my lord. Any
ইউনিভার্সালটা যেন না রাখি লাইব্রেরিতে আপনি বলুন, কেন ওতে নেই অনেক কিছু, সিরিয়াসলি মিসগাইডেড হয়ে যাবে। ওনারা আর্গুমেন্ট করছেন, আমরা জাজমেন্ট দিচ্ছি, জাজমেন্টের সময় যদি আমরা ভুল করি বলবেন, দরকার হলে লাইব্রেরিয়ানকে যদি না করে আজকের মধ্যে আমি তোমায় ডেকে পাঠাবো একদম, আমি কিন্তু বলে দিয়েছি ওপেন কোর্টে, তা নাহলে আমি এখনই ডেকে পাঠাবো। ওরা কি করছে কেনার লাঞ্চের মধ্যে
document listed in the above tabular statement shall be acceptable only if it meets the following conditions.
yes.
Namely, it is currently valid. The person in respect of whom such document is issued is entitled for the same. The authority issuing the document has not made any declaration that such document is not a proof of identity, address,
It's
date of
like the
birth.
teleological argument. Teleological argument is referred to something that refers to something else. It's like an infinite mirror.
Now, my lord,
So
prima facie,
for coming to this finding, there has to be a valid document, etc., etc. For that, maybe another valid document. To obtain that, you produce another valid. But at every stage, it's a documentary proof. That is what Mr. Nag says. No physical verification, and at the end of the day, you are producing an Aadhaar card.
no, my lord,
Aadhaar authority itself does not conduct any physical
no,
verification.
my lord, there is
That
no
is not in doubt from the act also.
no, my lord, any document
We get your argument that it's
no, any
based on
document that is produced before lordship as a prima facie possession document, my lord. None of the documents does go for a physical verification. Any document that I produce, my lord, gas bill, passport, my lord, passport also what physical verification offers with us, my lord. No, police verification. My lord, I stand corrected, my lord.
How far police verification is authentic, we don't go into that. We don't go into that.
That is other thing, my lord. Now, my lord, except passport, my lord, except passport.
But on
my lord,
paper, there is a police verification in
But-
passport.
But except passport, my lord.
Anyway, so you say documents are there, that is prima facie proof, need not be conclusive proof by physical verification.
No, my lord,
That is
except,
sufficient for the notice to be issued under this act.
yes, my lord. But except passport, there is no physical
Anyway, let us not go into that. Yes. There are several other documents for which physical verification
But
is
there
there.
is another thing, if your lordship permits me, that there is another judgment which has not been dealt with by that has been referred, my lord. But the ratio has not been appreciated by the learned single judge. If your lordship permits me, my lord, I will refer.
I
to that.
will permit you, they'll get a reply opportunity. Yes.
Yes, my lord. My lord, if your lordship kindly comes to the impugned order once, my lord.
Have you got copies of the judgment? No.
My lord, I have copies of the judgment, my lord.
Write the copies. Yes. Para?
My lord, paragraph number 32, my lord. আমার আরেকটা কপি কোনে ছিল কোথায় গেল? আমার আরেকটা কপি কোনে ছিল কোথায় গেল? Yes, ma'am. মানে paragraph number from paragraph number 32. Now, my lord, this judgment was not referred to by the learned single judge on the ground, my lord, because the facts and circumstances was that there had been a lease, and that lease has been that lease has subsequently been
Came into
terminated.
the second category of unauthorized document.
No, but my lord, the ratio of this judgment is, my lord, Justice Banerjee says, my lord, kindly, my lord, paragraph number 32. My lord, my point is that the ratio was not appreciated, my lord.
Show us the ratio.
Now, my lord, may kindly come from paragraph number 28, my lord. Page number 19, my lord.
Yes.
After the Ashoka marketing case, the question that is posed here should scarcely have arisen. Any further doubt is now settled by the Nusli Neville Wadia judgment. Though an estate officer under the said act is not required to be versed in law, he has sufficient powers to decide the question as to whether a noticee under section 4 of the said act is an unauthorized occupant, and it is an adjudication on such score against the noticee that will permit him to proceed to evict the occupant adjudged to be unauthorized. Now,
That is what we are saying also. We referred to section 4 to you. Section 4. That's why we referred to section 4.
So, that is
Section itself says, yes.
no, that is itself what the judgment.
But this is premised on the
My prima
fact
facie
that
proof
someone is in occupation.
No, Millard, that
Question of
was my-
unauthorized, the character of the occupation is unauthorized or authorized, that comes later. It circumscribes occupation. There has to be occupation in the first place. That is where they try to hit you.
No, Millard, that is what I refer, Millard. Now it is up to your election.
Mr. Nag, you have cited several judgments. We cannot pass the judgment right now. We'll reserve it for a few days. Try to be as quick as possible. But we'll extend the interim order till we decide. The interim order granted earlier, after the interim order granted earlier is extended till disposal of the matter, whose of hearing is concluded, whose of the matter is reserved for judgment. Great. Thank you. Thank you. Good arguments, Mr. Banerjee also. So Nag argues well, you also argue well, but his was a better case. Let us see whether you could turn us. Very good arguments. Yes. এটা দেখেন এই বইগুলোই এখন পাঠিয়ে দিন কতক্ষণ আসছে ওখান থেকে হ্যাঁ ও এটা তো ওদের বই তাহলে এটা আমাদের এটা দেখি এটার উপর একটু বসতে হবে কিছু তো দেখি
I had shown you lots of the conveyance yesterday. The next document that I had adverted to was the agreement. Well, I told you, Lordship, that this agreement, well, it really came about on account of a change of management of the transferor company Punalur. That agreement, your Lordship will find at page 187. What's the page now?
দিন ওগুলো দিন এখানে পেপারস গুলো থ্যাংক ইউ yes payments
Well, there are two page numbers. The printed page is 207 at the middle of the page, and then 187, well, written in hand. Well, this is FAT 142.
ওটাই তো কালকে হচ্ছিল ওটার তো এটা দিচ্ছেন কেন ওটা পুরোপুরি তো আর্গুমেন্ট হচ্ছিল কাল দীপঙ্কর এদিকে এসো ওটা রাখো
Page 187 or the
Of the-
printed page
in-
207.
yes handwritten 187
Yes.
we have got it.
That may I request your Lordship to please have a look at this agreement. Your Lordship seen,
Yes.
my lord, how under the conveyance, my lord, the entire actionable claim has also been transferred.
yes
My lord, this agreement is made, my lord, about 7 years after the conveyance in 2010. The
Right.
date is 15th May 2010.
yes
May I just read, my lord, portions of this agreement? my lord, your lordship sees, my lord, page 211.
211 is the power of attorney.
Well, 191 is the, my lord, handwritten.
Oh, 191. 191 is. Yes, you placed it yesterday.
No, I placed the conveyance. I did not show your lordship the agreement. My lord, the agreement is, my lord, I may have shown it to your lordship, my lord, on an earlier occasion. If your lordship has
Okay,
some
yes.
markings,
Yes, it's full.
that
fully
is
marked.
probably the reason. Well, if your lordship sees, my lord, well, at page 194, handwritten page,
Yes.
it is recorded that Lindsay is the sole and absolute owner of the land property being Nelly Sengupta Sharoni. Recorded that in pursuance of the understanding made at this treaty of sale, property is herein before stated. I hope I'm reading.
Realization is in the next paragraph. Yes.
Yes, my lord.
Para 3
Para 3.
or clause 3, whatever it is.
Yes, my lord.
Clause 3 is to realize the compensation amounts, mean profits, and to pursue the litigation.
That's it. No, no, my lord, conveyance আমি দেখিয়েছি কালকে.
5 is maintain and operate the bank account.
That's right. That's right. That is right, man.
But you have,
Well, that is right. Well, clause 1, my lord, if your lordship will kindly once, my lord, see.
yes.
Well, this is confirmation of the conveyance. It is recorded that Lindsay is the sole and absolute owner of the property.
Yes.
Then, my lord, because it is now, my lord, conveyed to Lindsay, recorded it in pursuance of the understanding made at the treaty of the said sale, property herein before stated, Lindsay has so far been perusing and prosecuting the said litigations and all proceedings thereunder concerning relating to the property, also taking appropriate steps for realizing, recovering compensation amounts. Then, my lord, Lindsay shall all times hereinafter be and entitled to continue to pursue the said litigations proceedings thereunder and such further other litigations or legal proceedings, and also to realize compensation amounts, mean profits, other dues. Now, my lord, 4 is important. Punalur hereby agrees and confirms that in case of realization of amounts towards compensation, mean profits, or otherwise with regard to the portion of said property, the same shall exclusively belong to Lindsay, and that Punalur shall not be entitled to any right of or claim any nature in respect thereof. Punalur further agrees that, my lord, it can, this is very important, my lord, entitled to maintain and operate a separate bank account being such and such, IndusInd Bank Upper Wood Street branch, in the name of the company for the limited purpose of receiving, realizing, and cashing amounts of compensation, mean profits, etc. And then 6, Punalur hereby also agrees to grant power of attorney in favor of Lindsay and or its nominees, authorizing and empowering them to represent Punalur as also to defend, contest, prosecute all litigations. Then, realize amounts of compensation money, mean profits, etc., etc. And, then, if your lordship sees, clause 8,
Yes.
Punalur hereby declares and confirms that appropriate resolution of the Board of Directors of Punalur have been duly passed for and on account of the provisions of clauses 3 to 7. Agree that if so required, Punalur would cause appropriate resolutions, further resolutions to be passed. And then 9, confirming parties above also named as the holders of the majority shares in Punalur as also being persons in control of management of Punalur hereby agree and confirm the said understanding and agreement and arrangement with Lindsay. Well, this is the sum and substance of
Yes.
this agreement. Now, if your lordship sees, the signatories to this document, on behalf of Punalur, your lordship will find
Yes.
that there is Sundareshan. Your lordship will see the persons who represent the company, I think signatures. If your lordship sees who are the confirming parties, please see page 189.
189.
189, my lord, this is the, these are the confirming parties. The first party is, my lord, the first party is Punalur. The second party is, my lord, Lindsay Towers.
Sundaresan is 3.
Then 3, my lord, 1 is Venkataraman, 2 is K. Ravindran, 3 is T.K. Sundaresan.
T.K. Sundaresan,
Managing Director.
subsequently, what did you, why are you?
My lord, he affirmed, he verified the plaint. All plaints verified by him, all actions now, my lord, brought by him.
They are challenging the existence of this agreement or the
Yes, they are
signature,
challenging the existence agreement and the conveyance. Both.
not specifically signature or anything like that. They say that there is no such agreement.
They have said that Malad, this was without proper resolution. Now, Malad, the doctrine of indoor
No,
management.
they don't deny the existence of the agreement,
No.
that there is no such agreement.
No denial of that.
You'll answer when you say that Mr. Shah is not submitting correctly when you get your chance. Yes.
Malad, no denial of the agreement, no denial of the Malad signatories to the agreement, nothing to that effect. Malad, what has been subsequently attempted to be said is that Malad, it did not have proper resolution of the board. Now, Malad, so far as this is concerned, Malad, the clear answer is the doctrine of indoor management. Malad, what you have done internally is Malad not something what I am supposed to know. But Malad, I need not address your lordship on that because the execution of this document is not denied. Now, Malad, thereafter, Malad, what happens is Malad, following this, the power of attorney, Malad, your lordship will find is executed. Malad, that your lordship will find at page 202.
Yes.
Handwritten.
Mr. Shah will just come back and.
Yes. Then, my lord, I'll not take your lordship to some of the other documents. We have the power of attorney was thereafter executed. My lord,
Yes.
that is at page 202. My lord, there's a first power of attorney of 15th May 2010. Then there's a second power of attorney that's executed, my lord, in 2011. My lord, that is at page 207. And my lord, then, my lord, what happens is, my lord, now the money starts coming in. Now, my lord, in 2021, my lord, there's a purported revocation of this power. My lord, page 212. Now, my lord, we have challenged the revocation of the power in a separate suit, and now we have an injunction in our favor saying that they can't, my lord, purport to revoke the powers. It is barred under section 202 of the Contract Act because the power of attorney was coupled with interest. My lord, I'll not trouble your lordship with that. Now, my lord, just one last set of documents to show you as to what, my lord, caused the suits to be filed. Please come to page 220. Well, 220, your lordship will find is a letter dated 25th February 2021.
Yes.
Well, now Punalur Paper Mills, the transferor is writing to the IndusInd Bank. We have changed the present authorized signatory and have authorized our managing director, Sri T.K. Sundaresan, to operate the above related current account with you. The copy of the board resolution is enclosed herewith. We request you to send us the necessary forms for his specimen signature. Request you to cancel the net banking facility in this account immediately and to issue appropriate directions in this regard. Well, there are a series of letters that follow. Next page again. March 21. Again, my lord, they're writing to the bank. Request not to honor any checks issued by the present signatories. And my lord, then again at page 222. So, my lord, these letters are there. My lord, not really relevant, except to show your lordship that, my lord, they now purport to, my lord, take control of that bank account.
Yes.
My lord, this results in, my lord, a suit that we filed, which your lordship will find at page 253. Well, this is title suit number 314 of 2021. Well, this is filed by Lindsay Towers against Punalur Paper Mills and, my lord, against, my lord, amongst others, Mr. T.K. Sundaresan. All the persons who were signatories to the agreement are mentioned here. And, my lord, I'll just show your lordship the reliefs that we have sought in the suit that your lordships will find at page 260. Well, this is for a declaration that the agreement of 15th May 2010 is in force, is subsisting and binding upon the parties. Declaration that the plaintiff has a right to operate and maintain the bank account. And, my lord, injunction restraining the defendants from closing the bank account. Yes, that's right. Basically with the bank account. Now, my lord, this results in, my lord, a cross suit being filed that your lordship will find at page 311. Okay. My lord, we obtained an interim order restraining them from closing down the bank account. My lord, the second, my lord, in point of time, my lord, after we file the suit, TS number 314, my lord, the appellants with your lordship file, my lord, file the TS number 613 of 2021. Now, my lord, I'll show you lordship. Well, at first, my lord, the prayers in the suit and some of the averments in the plaint. Well, this is second in point of time. But if your lordships will see, well, the parties to the suit, initially the party is only the bank. I was not made a party. Well, the defendant number 1 is the IndusInd Bank. Defendant number 2 is the chief manager. I was later added as a party to the suit. Now, well, so far as the prayers are concerned, please have a look at, well, at page 322. Well, this is the appellant suit, a decree for declaration that the plaintiff alone, that is, my lord, the appellant transferor, alone is entitled to operate its own account standing in the name of the plaintiff through its authorized signatory, Sri T.K. Sundaresan, chairman and managing director of the plaintiff company in respect of the said account number such and such, maintained with the Upper Wood Street branch. Declaration that the defendant bank has no authority to permit persons who are not associated with the plaintiff company in any manner to operate the bank account. And, my lord, other consequential reliefs. So, my lord, this is the suit that is filed. Now, my lord, let me show you, lordship, some of the averments in the plaint.
Hmm.
My lord, because, my lord, this is one of the plaints that was rejected.
Hmm.
Now, my lord, paragraph 1, plaintiff was the absolute owner of 13 Delhi Shooting Gupta. Was the absolute owner. They have sold. Paragraph 2.
Hmm.
By a nominal registered deed of conveyance dated 5th April 2023 was obtained by the plaintiff in respect of the land, multi-story building and 13 Melishon Gupta in favor of Lindsay Towers. So, my lord, this is an acceptance of the execution of the conveyance. Then, my lord, if your lordship skips the details of registration. Now, my lord, this is what they say. This is very important. The deed of conveyance, the same was brought into existence by undue influence, fraud, for which the plaintiff is initiating separate proceedings for cancellation. Till this day, no steps are taken in respect of the pending legal proceedings basing on such document. My lord, very important, because, my lord, here they accept the fact that there is, my lord, a conveyance of 2003. Well, they accept the fact, my lord, subsequent paragraph, that there's an agreement of 2010. They say that they have till now taken no steps to, my lord, challenge the same. They will be in future taking steps.
But
Well,
no
let-
leave under order to rule to issue.
That's right. No, my lord, leave under order to rule to, my lord, they were subsequently paid for. But that, my lord,
They made an application.
they made an application. Then, my lord, will please have a look at, well, at paragraph 4.
Hmm.
For the purpose of realization of the said amount, well, these are amounts that are coming in, well, that is mentioned in paragraph 3. For the purpose of realization of the said amount arising out of the land acquisition proceedings, several shareholders of the plaintiff, as confirming parties, now, well, this is important, without having authority and without any resolution of the said company, entered into clandestine agreement with Lindsay Towers to maintain operate a separate bank account number such and such with IndusInd Bank, Hare Street, in the name of the plaintiff company for the purpose of receiving, realizing, encashing amount of compensation. Now, well, who is saying this? Sundaresh. And, well, then paragraph 5, agreement is a clandestine deal with other shareholders, the plaintiff company at the time in 2010, without any due authorization of the said company, without any resolution, without the chairman and managing director being signatories to the document. Then paragraph 6, matter of record that the agreement was entered into at the instance of shareholders representing 52.76% of the shareholders, leaving aside the rest. 7, plaintiff has decided to take appropriate action for cancellation of the agreement of 15th May 2010 in separate proceedings. So, my lord, cancellation of conveyance in separate proceeding, cancellation of agreement in separate proceeding. Matter of record that highlighting the agreement dated 15th May 2010, Lindsay Tower Private Limited, renamed as Calm Industries, has illegally misrepresented, filed the title suit number 314 of 2021. Then, my lord, paragraph 9. This is a matter of record that since the execution of the agreement of 15th May 2010, there has been change of directorship in the plaintiff company. Paragraph 10. Resolution adopted by the Board of Directors of the plaintiff company on 25th February 2021, it was decided by the plaintiff company that immediate measures be taken for changing the signatories in the bank account. 11. Resolution was communicated to the bank. Then, my lord, 12 is, my lord, the factum of filing of our suit. In the meantime, on 6 March 2021, Lindsay Tower Private Limited filed the title suit number 314 of 2021, obtained ad interim order of injunction from the court of the learned 6th judge, restraining the plaintiff from closing down the bank account. Then 13, my lord, defendant bank issued a letter informing the plaintiff that the hands of the bank are tied, defendants are unable to accede to the request. And, my lord, this goes on. And, my lord, the cause of action now, my lord, paragraph 16, if your lordship sees. In view of the aforesaid facts, it is very essential to pass appropriate orders so that the defendant bank is restrained from permitting any person other than the plaintiff to operate the bank account.
It's rather surprising that Sri Sundaresan himself
Yes.
very wiser.
Now, my lord, what is very
He should
important
have been
is,
wiser, a bit wiser.
well, there are 3 grounds on which, my lord, this suit was challenged. I'll take your lordship, if necessary, to the application under Order 7, Rule 11. 3 grounds. One is, my lord, meritless, vexatious, does not disclose a clear right to sue, and that, my lord, is what has been held to be, my lord, the plaintiff fails to disclose the cause of action because it is a meritless and vexatious suit, my lord, supported by judgments. Secondly, my lord, clearly, my lord, so far as this is concerned, my lord, there is no question of bar of limitation here. Clearly, my lord, this, my lord, recognizes the fact that there are, my lord, subsequent causes of action which could have been, my lord, joined in the suit but not joined. My lord, that is, my lord, the challenge to the I'm not sorry, it's not subsequent, challenge to the conveyance and challenge to the agreement. Now, my lord, this is the first suit. Now, my lord, after this, my lord, they file a counterclaim in, my lord, in my suit, title suit number 314 of 2021. I am giving your lordship the sequence in order of time. Well, that your lordship will find at page 270. বাবা, এটা তো পড়েই যাচ্ছে না। Well, the first few pages are not very legible, but my lord, may I request your lordship to come to page 277? That is what is important.
So you're starting from the legible.
Yes. Para 9 এখানে, that is legible. Para 9 is legible.
This is sort of dark humor.
Yes.
73 to 72. Nothing.
I don't know, well, it seems to be deliberately redacted. Well, paragraph 9 is important.
Yes, para 9.
Aforesaid suit filed by the plaintiff is based on an alleged agreement dated 15th May 2010 signed by a few shareholders, which is a document executed on stamp paper of 100 and insufficiently stamped, and reliance can be placed on the said document for any purpose apart from the other illegalities associated with the agreement. Under the provisions of law, the said alleged document placed by the plaintiffs before this learned court as an alleged document, assignment, or amounts of acquisition is neither registered nor properly stamped. Then paragraph 10. It would also be proper to point out that the said unregistered agreement dated 15th May 2010 was a document executed after 7 years from the date of execution of the deed of conveyance. Purpose of execution of the said alleged agreement was for evading stamp duty required to be paid. Aforesaid suit has been based on the said agreement as no stamp duty has been paid along with the deed of conveyance regarding the purported assignment of receiving compensation in account of acquisition in respect of the property involved. It would be further proper to point out that the plaintiff had the opportunity of getting the deed of assignment executed by defendant number 1, but have chosen not to do so as per understanding between the parties, and now they are claiming for taking away the entire compensation amount without there being any assignment of the same on a registered document. For all practical purposes, alleged agreement of 15th May 2010 is void ab initio in view of the fact that the same has been signed by a few shareholders who had no authority to take decision on behalf of the defendant number 1, which was a public limited company. Without approval of board of directors, shareholders cannot act on behalf of the company. Furthermore, there is a stipulation in the said agreement that the said agreement shall have to be ratified by passing appropriate resolution in a meeting of the board of directors, but unfortunately, said document was kept in the shadow for such a long time, and after bringing the same to light, now a declaration with regard to the validity of the agreement has been sought before the learned court. Then, my lord, again, paragraph 13, no resolution ratifying the agreement. My lord, then paragraph 14, in the deed of conveyance between the parties dated 5th May 2003, there was no assignment of the compensation receivable from acquisition authorities in a separate schedule of the deed. Neither the same was assessed by the registering authorities nor any separate stamp duty was paid. Fully aware of the aforesaid legal position, plaintiffs have never harped for the right of entitlement of acquisition amount on the basis of deed of conveyance, but have tried to establish their claim on the basis of alleged agreement of 15th May 2010. Unfortunately, agreement of 15th May 2010 is subject matter to be decided with regard to validity in the suit, etc. And then please come to paragraph 16. Matter of record that the acquisition process started long before the transfer of the property in question in favor of the plaintiffs. Moreover, consciously no deed of assignment was executed in favor of the plaintiff, and accordingly money awarded in acquisition proceedings shall belong to the plaintiff, to the defendant number 1 and nobody else. Then 17, my lord, allegation to, my lord, alleged fraud without any particulars. Mastermind behind the aforesaid matter, Mr. Kunal Dalnia, was originally the director of both Punalur Paper Mills and Lindsay Towers. As there was a loan agreement of 3.5 crores, my lord, alleging that the transfer was made for, my lord, less than, my lord, the market value. Not important at this point. And then please come to paragraph 20. Plaintiff has all along maintained the said account in the name of the defendant number one. Even today, the said account stands in the name of the defendant number one. But cunningly, Mr. Kunal Dalmia, who ceased to be a director of the defendant number one company, since long kept on representing to the bank authorities that he is one of the directors of the defendant number one company and has right to operate the bank account of Punalur Paper Mills. My lord, this is the allegation. Then, my lord, please come to paragraph 22. That if the plaintiff's right with regard to the entitlement of acquisition amount, they ought to have certainly resorted to file appropriate application for transposition of their name in the acquisition proceedings. But they could not do so, as under law of the land, the entire acquisition money was to be accrued in the hands of the defendant number one, as the acquisition took place when the ownership of the property in question was with the defendant number one. Alleged agreement of 15th May 2010 is the subject matter of dispute in the aforesaid suit. Plaintiff has on its own sought for declaration upholding the legality validity of said agreement. Then, my lord, coming directly to, my lord, what is their cause of action in the suit? If your lordship sees, my lord, they allege that the agreement, my lord, is not valid because it was not, my lord, passed by a board with appropriate resolution. Then, my lord, paragraph 37. That the defendant numbers 1, 2, 4, and 5 are also entitled to a decree for declaration that the plaintiff has no authority to do any act in furtherance of the said agreement dated 15th May 2010, executed by some of the shareholders of Punalur Paper Mills in favor of Lindsay Towers Private Limited before any authority concerned, including bank authorities, land acquisition authorities, on the basis of the alleged agreement. Defendant numbers 1, 2, 4, and 5 are also entitled to a decree of permanent injunction restraining plaintiff from giving any effect or further effect to or relying on the alleged agreement of 15th May 2010, executed by some of the shareholders, etc., or from representing, my lord, before land acquisition authorities. And then, my lord, please see 40. This is most important.
Yes.
That the cause of action of the aforesaid counterclaim arose in the second week of March of 2021, when the directors of the defendant number one received a notice of injunction together with the copies of the plaint and injunction application in respect of the aforesaid suit in the second week of March 2021, and for the first time became aware of the suppression that has been made by CUM and other office bearers of the plaintiff company, and the said cause of action arose at Upper Wood Street branch. Well, I have not been able to understand what is, my lord, the suppression, or what really is, my lord, the notice.
Suppression that you have perpetrated fraud on them.
Yes.
You have suppressed that. That is only suppression.
Yeah, I think, my lord, that is the my lord, right way to look at it.
Yes.
And, my lord, then the press, your lordship will find declaration that the agreement of 15th May 2010, my lord, is void, not binding upon the defendant number one. Plaintiff has no authority to act in furtherance of the agreement. Annual injunction restraining, my lord, parties from giving effect to the agreement. Now, my lord, so far as this is concerned, my lord,
Limitation.
my lord, counterclaim is against challenge on the ground that, again, meritless and vexatious, clearly barred by limitation. And, my lord, they could have taken this point, so order to rule 2.
Yes.
My lord, this is followed by, my lord, the next suit that is filed. Now, my lord, I'll just give you, lordship, the date of filing of, my lord, the suits. My lord, the first suit 613 of 2021 was filed on, I'm sorry, their first suit was filed on 6th April 2021. That is 613 of 2021. This counterclaim is filed on 15th of July 2021. And then, my lord, the next suit that, my lord, my learned friends came to file is TS 430 of 2022. My lord, that is filed, my lord, on 21st of February 2022. Now, I'll take your lordship directly to the plaint file in that suit. Now, my lord, in the counterclaim, my lord, they assail the agreement. Now, my lord, in the subsequent suit that is filed in 2022, they assail the conveyance. My lord, that your lordship will find at page 363.
The last page of that is in which language?
Last page of?
Kollam must be 426 page.
Yes, ma'am. 426, देखिए नहीं तो. মিস করে গেছি।
Junior Mr. Shah may be able to help you by using certain apps. Sorry, Mr. So I forgot you were on a device.
Oh, yes. Appears to be in Telugu.
Kerala.
Punalur is in Hyderabad.
Malayalam also, Kerala. Kollam.
Oh, Kollam. Yes, must be Malayalam. Well, coming back, Malad, to the plaint at page 363.
363, yes.
Well, paragraph 4 is important. Page 364.
Yes.
The present suit is filed primarily seeking cancellation of a purported deed of conveyance dated 5th April 2003 on the ground of fraud, misrepresentation, suppression of fact, documents in respect of land, multi-story building, etc. Deed was purportedly registered in the Additional Register of Assurances, Kolkata. Said deed was executed on behalf of the plaintiff by director of plaintiff. And then, well, allegation that sold at an apparent undervalue, that is paragraph 13. Well, it's not really important. What I will show you, Lordship, is the prayer. Well, now, or your Lordship may have a look at the particular so-called particulars of
Para
fraud.
51 on the last question you placed. Para 51.
51. Para 51. Well, these are the so-called particulars
Those are
of fraud.
similar.
Yes, paragraph 56.
Yes, 56.
And then the prayers.
Yes.
Paragraph 56, cause of action. This is important.
Yes.
Cause of action in the present suit arose when the plaintiff came to learn the true facts concealed by the defendant number 2 on receipt of email of 24th March 2021 from the IndusInd Bank enclosing the bank statement, which is completely different, etc. Now, they are challenging a conveyance. They were aware of the conveyance at least in 2010. This suit is being filed in 2022. And apparently, the cause of action to file the suit arises on notice from bank. I don't know how that be the case. And the decree is for delivery and cancellation of the deed of conveyance. Now, these are the 3 suits. Now, in respect of each of the 2 suits and the counterclaim, we file applications under Order 7, Rule 11.
So the grounds of challenging Order 7 Rule 11 in the third suit is similar to the counterclaim.
Yes, sir. Yes. Meritless, vexatious, limitation, and order to rule.
Yes.
Now, may I straight away now show you, Lordship, of course,
aggravated order to rule too, because in the previous counterclaim also,
yes,
deed was not challenged.
Yes. Now, so far as order to rule 2 is concerned, before I show you, Lordship, the impugned order, may I just show you, Lordship, a recent judgment, whereas your Lordships were pleased to point out yesterday, order to rule 2 is, of course, discussed. But also the question of, constructive res judicata, drawing inspiration probably from section 11, explanation 4. That is also discussed. This is a recent judgment of the Supreme Court. This is reported in 2026 SCC Online SC 552. This is Justice Dipankar Dutt.
Yes. Could be either of Justice Datta or Justice Padiwal.
Yes. In some cases, Justice Vishwanath.
Yes, they share between. Yes. They are sharing between themselves the landmark judgments on the.
And sometimes we find Justice Vishwanathan also,
yes,
coming in.
Justice Narasimha is also joining the fray.
Yes. And also Justice Sanjay Kumar.
Sanjay Kumar is also.
Yes. He's also coming up with some of these judges. But mainly, as your Lordship pointed out, the burden is being shared by Justice Datta, Justice Padiwala, mainly. আমার কাছে এইটা কপিটা নেই। Kindly give me a moment. I have the decision. Paragraph 17 is probably the paragraph. I'll just see whether it corresponds to. Yes. Paragraph 17. It was further urged by Chanappa that such and such in her evidence had specifically acknowledged that Chanappa was claiming ownership over the suit properties. Having been aware of such assertion of right, Parvateva ought to have sought declaration of her title and the appropriate consequential reliefs in suit 1. Omission to do so, it was contended, attracts the bar under
Okay.
order to rule 2 CPC.
This was against a decree.
Yes. Per contra, learned counsel for the Parvateva contended that the two suits were founded in distinct causes of action. According to them, earlier suit was confined to the validity of adoption deed, whereas the subsequent suit arose out of the alleged disposition of Parvateva. It was therefore argued that suit 2 could not be said to be barred either by res judicata or by order to rule 2 CPC. Then paragraph 20, the doctrine underlying order to rule 2 CPC is founded upon the salutary principle that the defendant ought not to be vexed twice for the same cause of action. Plaintiff must claim all reliefs arising from a single cause of action in one and the same proceeding. Where a plaintiff omits to claim a relief which he or she is entitled to claim on the same cause of action, he or she is precluded from instituting a subsequent suit for such omitted relief. Then reference is made, my lord, to Gurbakh Singh. Well, I'll not trouble your lordship, my lord, with what is said there. Then paragraph 22. Applying these principles to the present case, it becomes evident that Parvateva had already approached the court in the earlier proceedings on the basis of the same underlying dispute relating to the rights over the suit property. The foundational facts giving rise to the cause of action, namely the claim regarding entitlement to the property, were already in existence at the time of the earlier suit. A comparison of pleadings in the relief sought in suit 1, suit 2, whether that is made. I'll not trouble your lordship with that. Then paragraph 24. Despite being fully aware that Chanappa had denied her ownership and had asserted rights on the basis of the family arrangement deed of 1998, Parvateva chose to institute suit 1, merely seeking injunction simpliciter without seeking the necessary and consequential relief of declaration of title. Once Chanappa had clearly contested Parvateva's ownership in the pleadings, it became incumbent upon Parvateva to seek the comprehensive relief of declaration of title along with consequential relief of injunction. Omission to seek such relief in suit 1 is significant and cannot be cured through a subsequent suit. Importantly, there is nothing on record to suggest that Parvateva obtained leave of the court to reserve these reliefs for a future proceeding. The consequence of such omission is clearly contemplated under Order 2, Rule 2.3 of the CPC, which bars the plaintiff from subsequently instituting a suit. And then, my lord, reference is made to, my lord, a couple of other judgments. Then, my lord, will please see, my lord, paragraph 28.
Yes.
The subsequent institution of suit 2 seeking declaration of ownership and recovery of possession in respect of the same property and between the same parties is therefore clearly hid by the provisions of Order 2, Rule 2. Then the principles of constructive res judicata embodied in explanation 4 to section 11 CPC also becomes relevant in the facts of the present case. A matter which might and ought to have been made a ground for attack in the formal proceedings shall be deemed to have been directly and substantially an issue in such proceeding. Parvateva having omitted to seek such appropriate relief in the suit 1, despite being aware of Chanappa's claim, cannot be permitted to agitate the same by way of subsequent suit. Reference again made to, my lord, judgments of the, my lord, Supreme Court, etc., etc., and, my lord, the conclusion. That big decree হয়ে গেছিল, but that is by constructive decree হয়ে গেছিল বলে.
Yes, in that case. The previous suit was decreed. We don't find that.
Yes,
Previous suit had been decreed.
yes, my lord. The suit 1
Had been decreed.
had been decreed.
So that's why
that's
here
why-
constructive res judicata comes.
That's it. That's it. Otherwise, it would not. Now, my lord, so far as this is concerned, now, my
The
lord, if I may-
confusion arises because 28 of 28, para 28 and 29 being following each other in a manner that as if it follows from there.
That's right. That's right.
Independently also that is applicable.
Yes. Now, my lord,
Here you don't have constructive res judicata in your
No.
case.
no, I cannot.
Thankfully.
I cannot. Yes. My lord, now, my lord, coming to, my lord, the impugned orders. Now, my lord, I have to take your lordship, my lord, through the orders one by one. There are 3 orders. Because, my lord, there are 2 rejection of plaint, 1 rejection of counterclaim
By separate orders.
by separate.
Different dates also.
No, but the date is the same, but the orders are separate orders.
If it's a copy paste, then we can
Yes, my lord. I'll,
one.
no, one order, no, alada order. My lord, if I may, my lord, show your lordship, my lord, 613 first. My lord, this order of 6th April 2024. My lord, that your lordship will find from, my lord, if my lord, this is a, now I have to take your lordship through the separate memorandum of appeals. My lord, FAT 143. My lord, this contains the judgment in, my lord, 613, title suit 613. Order number 71 dated 6th April 2024.
মেমোটা নেই। মেমোটা কি এখানে থাকবে? থাকা উচিত। এটা তো ইয়ে না, FA 81 এ করা আছে, দেখছি
সেপারেট অর্ডার দিয়েছি, সেপারেট অর্ডার দিয়েছি।
এইটা হবে যত ক্যাভিয়েট মেমোটা দেখি।
আমি অর্ডার 613 টা আগে দেখি, that is first in point of time. Have your lordships got? That's FAT 143.
Yes, that has become FA 81.
Oh, FA 81. ঠিক আছে।
অন্য ফাইলটায় ঢুকে আছে, ছেড়ে দিন। অন্য ফাইলটা ঢুকে আছে, পেজ দুটো তো একই নাম্বার পেয়েছি। দুটোতে FA 81 লিখেছে, নাম্বার অফিস। FA 81 কোনটা?
FA 81.
81 তো FAT 142 না 3? 3টা এদিকে দেখিয়ে বলুন। 143। ঠিক আছে। Yes, Mr. Shah. Let us proceed with this. No, but এখানে তো অন্য একটা রয়েছে। ঠিক আছে, দেখে নিচ্ছি। Yes, please let us carry on.
Yes, ma'am. Well, if your lordships, my lord, have the order number 71.
71, yes.
Yes, my lord, please come to my lord. The last paragraph in the first page.
Same order number, same date also, but no, these are different orders.
That's why, my lord, I have to trouble your lordships, my lord.
No question. Yes.
Well, if your lordship sees the, my lord, last paragraph in the first page of the order, which starts
Yes.
with in paragraph 2 of the plain. In paragraph 2 of the plain, the plaintiff, Punalur Paper Mills, has admitted that a registered deed of conveyance dated 5th April 2003 was obtained from the plaintiff in respect of land multi-story building at 13 Nelishan Gupta Sharoni. While alleging that the said deed was brought into existence by undue influence and fraud, it was worth noting that the plaintiff till date has initiated no proceeding for cancellation of the same by stating that, and then, my lord, portion of the plaint are reproduced, my lord, clandestine agreement, etc., etc. Then, my lord, the second page, my lord, towards the middle of the page, my lord, starts with, my lord, plaintiff decided to take appropriate action for cancellation of the agreement of 15th May 2010 in a separate proceeding. It is therefore clear that though the plaint proceeds on the premise of the agreement of 15th May 2010 was a clandestine agreement entered into without an appropriate authority or resolution, there is no explanation whatsoever as to why the plaintiff did not proceed to challenge the same even in the instant suit being title suit number 613 of 2021. It is worth noting that it is not the plaintiff's case in the instant suit that the plaintiff was not aware of the conveyance of 5th April 2003 at the time of its execution and registration, or of the agreement dated 15th May 2010 at the time when the said agreement was executed. Significant to note that one of the signatories to the said agreement of 2010, Mr. Sundaresan, is now seeking to challenge the agreement executed on 15th May 2010 through the plaintiff and have verified the plaint on behalf of HON'BLE Paper Mills. Moreover, the acceptance of the deed of conveyance of 5th April 2003, which inter alia proceeded to transfer the actionable claims of the plaintiff to receive compensation from the pending acquisition requisition proceedings, and further in view of the acceptance of the agreement of 15th May 2010, under which the plaintiff authorized defendant Calm Industries open and operate a separate bank account in its name for the purpose of receiving compensation from such acquisition requisition proceedings, coupled with the fact that no action to challenge it should be either the conveyance or the agreement of 2010 has been taken till institution of the present suit, clearly demonstrates that the instant suit filed by the plaintiff does not disclose any cause of action, since the plaintiff's purported cause of action in the said suit is founded on alleged fraud accompanying the acquisition of the agreement of 2010, and in the absence of any challenge to the said agreement either prior to or at the time of filing of the instant suit, the plaintiff clearly has no cause of action to assail the operation of the bank account opened with the IndusInd Bank on the strength of such agreement. Then, my lord, for your lordship, when it comes to my lord, Order 7, Rule 11, my lord, application is filed, that is, my lord, mentioned. And my lord, then, well, if your lordship sees the last paragraph of the page, in the given circumstances, the plaint filed in title suit number 613 of 2021 clearly does not disclose any cause of action, and thus, in my humble submission, opinion, the plaint is liable to be rejected on such ground alone. Moreover, the court has taken support from a decision of the Honorable Apex Court in such and such, where the Honorable Court has held that plaint can be rejected under Order 7, Rule 11. If the conditions enumerated in the said provisions are fulfilled, it is needless to observe that the power under Order 7, Rule 11 can be exercised by the court at any stage of the suit. Relevant facts for which need to be looked into for deciding the application are the averments of the plaint only. If on an entire and meaningful reading of the plaint, it is found that the suit is manifestly vexatious and meritless in the sense of not disclosing any right to sue, the court should exercise power under Order 7, Rule 11 CPC, since the power conferred on the court to terminate civil action at the threshold is drastic. Conditions enumerated under Order 7, Rule 11 to exercise the power of rejection have to be.
Shah, we have seen this order.
Yes.
Limitation is probably not correct.
No.
Because
well, this
construing that should have been challenged, and if it was challenged, it would be barred by limitation.
Yes, sir. Now, well, so far as this case is concerned, well, here your lordship will remember is challenge to the bank account. Well, so well, the limitation
Meritless vexatious.
not really well in issue. It is really meritless and vexatious. Well, this is the first judgment or not.
For that, one of the considerations maybe if those were challenged, those would be time barred, and
Yes.
that's secondary logic.
That's it.
Right.
So, but here the first suit, it's really meritless vexatious
Yes.
in the manner that it does not really disclose a clear right to sue.
Yes.
Well, that is right from 77 Supreme Court onwards. Justice Krishna Iyer,
Arvindandam.
yes.
Yes.
Now, the next judgment, is
the pronunciation of Arvindandam is like irretrievable.
Yes. But then it says you have to go to a trial.
Yes.
Well, then, if your lordship sees the next judgment, this is in the counterclaim. This was FAT 149. What is the FA number? 127. FA 127, I'm told. Well, this is also, again, 6th April 2024, order number 70.
মেমোটা দিন বার করে উপর থেকে ওটা না না উপরে খোঁজা মুশকিল আছে
হ্যাঁ ঠিক আছে ঠিক আছে
Yes.
Well, order number 70.
This is effective
2024.
FA 127, right?
Yes. Well, application under Order 7, Rule 11, on the ground that the instant counterclaim is hit by the provisions of Order 2, Rule 2, where the defendants were required to crave leave to initiate appropriate proceedings for declaring the agreement of 15th May 2010, which was allegedly bad in law, being induced by fraud and misrepresentation. Contended by the counsel that for the plaintiff that in title suit number 613 of 2021, the defendants have contended that they asked for leave to initiate appropriate proceeding in paragraph 7 of the plaint, though the same has not been disclosed in the prayer portion of the plaint. Now, in paragraph 7, you lordship remember they said we have not yet filed, but we propose to file. More so, on the basis of such pleading, no leave was granted by court, even assuming that such informal disclosure of the leave in the plaint was not to be fatal, as alleged by Punalur. It is relevant to note that formal application under Order 6, Rule 17 of the Code of Procedure was filed, incorporating the said pair in the body of the plaint by the defendants, while the court was hearing the application under Order 7, Rule 11. But the fact remains no amendment or pleading at this stage in the plaint will cure the defect of the counterclaim being filed without proper leave of court to challenge the agreement of either 2003 or that of 2010. Then, my lord, may I request your lordships to skip over, my lord, 1 or 2 pages and come to, my lord, page 3 of the judgment, the last paragraph. Having opined thus, the submission of the learned counsel appearing on behalf of the defendants, that as soon as the fraud and misrepresentation was unearthed, they had filed the counterclaim in the suit being titled suit number 314 of 2021 filed by Lindsay Towers within the limitation period as prescribed in section 17 of the Limitation Act, that is within 1 year from the knowledge of fraud and misrepresentation, is not acceptable to this court. It is therefore evident from bare reading of the counterclaim and annexed documents of the plaint, which has been referred to by the defendants in their counterclaim, that the counterclaim is not only hit by the provisions of Order 2, Rule 2 of the Civil Procedure Code, the same is also thoroughly barred by the laws of limitation. Undoubtedly argued often that the fact of limitation is a mixed question of fact and law. However, in the present case, the discovery of fraud and misrepresentation which the defendants sought to argue before this court is unacceptable in view of the fact that there is no statement in the counterclaim to the effect that Punalur or the defendants was not aware of the conveyance of 5th April 2003 or the agreement of 15th May 2010 at the time of their execution. Counsel appearing for the defendants invited the attention of this court to paragraph 40 of the counterclaim, where it has been alleged that the defendant's cause of action to file the instant counterclaim arose in the second week of March 2021, when its directors received a notice of injunction together with a copy of plaint and injunction application filed in title suit number 314 of 2021. This, in the opinion of the court, cannot be the starting point of limitation in the suit, as all grounds urged from paragraphs 9 to 15 in the counterclaim were available to the defendants, irrespective of filing of the title suit by the plaintiffs, Lindsay Towers Private Limited. Further, there is no pleading in the counterclaim as to why it did not challenge the conveyance of 2003 and the agreement of 2010 for the past 11 years. Another aspect which requires mention is that the counterclaim itself recognizes the deed of conveyance of 5th April 2003 and the fact that the premise number 13 Nelishan Gupta Sharoni stood transferred thereby. Although the deed of conveyance expressly records the transfer of the compensation receivable in respect of the property under the acquisition requisition as well, this was never challenged by the defendants. The counterclaim filed in the title suit number 314 of 2021, in defendants have for the first time attempted to challenge the agreement on the ground that the same is not sufficiently stamped and registered, and consequently the chosen action or actionable claim in such compensation could not be transferred. But the fact remains that the transfer of the chosen action in the compensation receivable was done by the deed of conveyance itself, which was duly stamped and registered. In my view, above discussions, I have no qualm in holding that the instant counterclaim is barred by limitation hit by the provisions of Order 2, Rule 2, as well as therefore it's liable to be rejected as vexatious action. Well, the next judgment, really follows suit. Just as a matter of abundant caution, section 130 of the Transfer of Property Act, which talks about transfer of counterclaims, that does not talk about registration. I'll just show you, Lordship, what is the language of section 130. That is the relevant section. You have a copy of the, yes. 130 of the Transfer of Property Act. Yes. A transfer of actionable claim. The transfer of an actionable claim, whether with or without consideration, shall be effected only by the execution of an instrument in writing, signed by the transferor or his duly authorized agent, shall be complete and effectual upon the execution of such instrument, and thereupon All rights and remedies of the transferor, whether by way of damage or otherwise, shall vest in the transferee, whether such notice of the transfer as is hereinafter provided be given or not. Well,
In the Registration Act, there is
no,
there-
there's no requirement, my lord, so far as actionable claim is concerned.
in Registration Act there is nothing.
No, my lord.
Even if there is the court's logic is also apparently sound that it was done by the transfer was done by the deed,
By the deed, which was registered.
and this was a recognition sort of
Yes, my lord. This was, my
by
lord,
the subsequent management.
yes, my lord, this was only, my lord, a ratification of what had happened earlier, because the new management, they should not come later and, my lord, contend that, oh, we did not know this and that.
And the power of attorney also it's indicated that the person is now in control of.
Yes.
So that also gives an indication.
Power of attorney executed in pursuance of the agreement of 2010. And it says, agreement of 2000 says power of attorney will be irrevocable.
And the use of the expression persons in control of the company and all also indicate maybe justify your submission that this was done due to the change of management.
Well,
Generally, what is used is the company or the Punnalu paper means itself.
that's it. That's
So the persons now in control and management, that shows that they were now ratifying whatever.
That's it. And my lord, the last judgment, my lord, is more or less, my lord, a cut copy paste of, my lord, the judgment rejecting the counterclaim.
Yes.
My lord, that your lordship will find is, my lord, FAT 142. What is the FA number?
81.
81. Oh, এটা তো হয়ে গেল দেখানো। না, এটা দেখায়নি, sorry.
142 is must be FA something else.
My lord, 142. My lord, is, my lord, the dismissal of the TS number 430 of 2022.
FA 8 now. FA 8. Yes, it is FA 8. FA 8 কি করে হলো?
8.
তো এখানে 8
FA 8, yeah.
FA 8, yes.
My lord, this is very similar to, my lord,
এত difference in number কি করে হলো?
my lord, order rejecting the counterclaim. Same date, 6th April 2024.
Honorable Patricia. Yes.
Well, if my lords take, my lord, the last paragraph of the first page,
Yes, yes.
my lord, this is the challenge. The second last, my lord, last line of the second paragraph. My lord, proceeded to allege frauds perpetrated against him in the matter of execution and registration of deed of conveyance. My lord, this is the subject matter of, my lord, the suit. 430 is the challenge to the conveyance. And then the court records.
Must be on similar, yes, but by
Yes.
limitation 2 and
Yes, my lord, that's right. I need not, my lord,
need
trouble
not
you,
place
lord.
there.
Same.
Same logic.
My
Yes.
lord, this is the same thing. Now, my lord, so far as this is concerned, the question, my lord, therefore, what my learned friends will have to show that, my lord, they had knowledge, my lord, so far as the allegation is fraud in both cases. 15th, my lord, May 2010 agreement. Allegation is it was fraud because, my lord, it was executed by persons in 52% shareholders, balance left out, no resolution of the board of directors. But I'll not go into that aspect because, my lord, that is a separate jurisprudence altogether, my lord, doctrine of indoor management. But, my lord, what is important here is that, my lord, the persons who are themselves signatories are the persons who are now, my lord, filing the claims.
Apparently, fraud was put into bringing the doctrine of fraud vitiates on
Yes.
those principles.
Yes, but, my lord,
So,
even
to
then,
dilute the limitation.
but even then, my lord, even if
knowledge of fraud was there.
yes, my lord, then, my lord, from the date of knowledge of fraud, you have to bring the action within 3 years. My lord, that is not done. So, my lord, this is really the sum and substance of, my lord, my defense to, my lord, their allegation that, my lord, these orders were passed without, my lord, due consideration.
Yes.
My lord, I will not trouble your lordship with much less, my lord, except just to, my lord, we have prepared a notes of arguments, my lord, which gives, my lord, a list of all the judgments. My lord, these judgments, my lord, I don't have to formally place because
How many judgments?
on, my lord, meritless and vexatious does not give a clear right to sue. But I'll just tell you, lordship, the headings. My lord, one is,
How
my lord,
many? You're avoiding the question, Mr. Shah.
my lord, about 7 or 8 judgments. Well,
On merits, it's a meritless and vexatious citation.
On that, my lord, there are 2 judgments. Meritless and vexatious, 2 judgments. One is, my lord, 77 Supreme Court, and the
Yes.
other is, my lord, 2017 volume 13 Supreme Court cases.
Ajay.
That is Ramachandra Murthy.
And what are the other judgments on?
Well, other judgments I don't think your lordship need trouble with. One is, my lord, counterclaim is an independent suit, my lord, so independent application. I'll not, my lord.
What is disputing?
I'll not cite those judgments, my lord. Then, my lord, plaint alone has to be considered. Then, my lord, so far as
So you ask your learned junior to tick mark those judgments which you are relying on,
no, my lord, I'll just, my lord, rely on two judgments.
which you want us to look into.
I've showed you, lordship, my lord, the Chanappa judgment, Justice Dipankar's judgment, and my lord, I think, my lord, I will only rely on two judgments.
So please
just-
mark those judgments which you want. to
Just these two judgments. That's all. My lord, these are my
not
submissions.
not in a platonic way. You have to mark it physically.
Paras 31 and 32.
Okay, I'll do it. I'll look into it myself. Don't do this. You
We'll
file
do it
common
right now.
notes of arguments, no?
Before filing, just have it checked.
Yeah, I'll just look into it
Mr.
myself.
Cyrus. In any event, Mr. Banerjee will probably not be arguing today.
That's it. My lord, there is a fourth appeal, my lord, which Mr. Banerjee has also, my lord, argued. My lord, that, my lord, is my
Fourth
lord,
appeal
that
is
is,
against-
my lord, against an order of 18 June 2024. The appeal number is 297, FMET 297. My lord, that is, my lord,
সেটা আমাদের কাছে আছে।
My lord, the argument with regard to that has not been made,
Very well.
Mr. Banerjee.
very well.
So
I'll
for the
wait for
timing,
Mr. Banerjee to argue that. My lord, these are my
that
submissions.
is against what? Injunction or?
No. Yes, my lord.
My lord, that, my lord, allowing me to operate the bank account and restraining them from interfering, my lord, that is the subject matter of judgment. Well, I'll deal with it.
She has not argued with that. You have argued this. The reply. They'll give a rejoinder to this, and we'll close arguments on
Very
these
well,
appeals. Then
very
we'll look at
Very well. Well, then we'll close
that.
this.
That will depend on whether the plaint remains or not. Also. So this is all, Mr.
Yes, ma'am.
So would you like to file this written notes today or?
Yeah, I'll do it today. I'll just check it myself once and then file it.
Mr. Banerjee will be arguing next day or today?
My lord, next day, my lord.
Next day. Very well. Next Wednesday, then we are putting it. The next
Yes.
year. Right.
Yes. My lord.
My
Lord,
lord, IndusInd Bank in item number 3.
Learned.
FA 81.
Yes.
My lord, I am appealing for IndusInd Bank in FA 81 of 25.
What do you? We can't see you.
Oh. My lord, am I visible
Yes.
now?
Yes, you are appearing for whom?
My lord, for IndusInd Bank in FA 81 of 2025.
Acha, just put it in the inbox or wherever. We'll just take.
My lord, I have given my name.
Yes, yes. Very well.
The list of citations should be given to us, my lord. The
Yes,
citations.
Learned Junior is here, Mr. Banerjee.
I'll give a copy of my notes of arguments. I'll just, my lord, make it shorter, remove all the unnecessary judgments so that your lordship does not have to physically depend on which is ticked out and which is not, my lord, ticked out. I'll do that.
Then file it on the next day.
Very well.
You have just check it and file it.
I'll do that.
We are not recording anything on the written notes today. Arguments of learned senior counsel appearing for the respondent is concluded. Full stop. For rejoinder arguments by learned counsel for the appellant, comma, on the prayer of learned counsel for the appellant, comma, the matter stands adjourned till July 22, 2026. এটা পাঠার হেডিং ই থাকবে যেরকম আছে এরকম থাকবে
Grateful.
থ্যাংক ইউ মেমো গুলো না একটা জায়গাতেই থাকবে আপনারা একটা খেয়াল রাখবেন মেমো গুলো যেরকম আজকে লিখেছি তাহলে আপনাদের এরকম বারবার খুঁজতে হবে মেমোরান্ডাম গুলো যেগুলো অর্ডার একটা জায়গাতেই থাকে এই তো ঘুরে ফিরে এক জায়গাতে পরে না হয় চেঞ্জ হবে আপাতত হিয়ারিং এর চলাকালীন মেমো গুলো যে কোনো একটা বেটার হচ্ছে যেটা এইটার এই ফাইলটার সঙ্গে yes
Next, my lord, will
Take one.
recall, my lord, this
I
is
have
the
to read it.
arising out of intellectual property relating to. Yes. Whether disparagement comes within the Commercial Courts Act or not. I had made my submission. Mr. Bachawat wanted to come back on the issue which had fallen from my lord. That it is very wide now. The Commercial Court's jurisdiction is wide. The earlier judgment was under the Trademarks Act and not under the Commercial Courts Act. And we are nearly finished our argument. Mr. Bachawat just wanted to come back on the issue with.
Where is he?
My lord, Mr. Bachawat is in courtroom 32. I'm told he's on his legs. Would my lords kindly take it up at 2 p.m. today?
2 p.m. will he be available?
He will be
If we
available.
start hearing of another matter, it will be difficult for us to take it at 2. Because all these are hearing matters.
But a short possible mind.
Whichever way, we would really like to, whichever way it goes, because it's really been.
Yes, yes.
And Jenny, no, doesn't like to keep on.
Understood.
Hearing matters.
He's
So,
available today.
because last occasion it was getting over, but Mr. Bachawat wanted
that. Yes.
because we had made a submission shown that judgment.
Mr. Banerjee
on
would do
that.
this. We'll do this. We'll keep it next Wednesday. We'll keep it at the top next Wednesday and request both of you to file a brief written notes of arguments.
We will do that.
So that it cannot be prolonged further. You will also come prepared with the written notes and Mr. Bachawat will address that. Please exchange copies because whatever Mr. Bachawat, you have not heard him as yet on this.
My lord.
So include that in your written notes, give a copy to them and they'll also give a copy.
We'll do that. That will be absolutely.
That will be better. It will
that will
conclude
be better.
That will be conclusive.
Because we had made our extensively, has already heard
I
us.
have also taken notes, Mr.
Yes,
Banerjee, but
yes.
frankly speaking, there's a gap. So
That's right. That's
so that we don't miss anything. And they'll
once I can just run through whatever we had argued. If wants, otherwise we'll come with the notes. Whatever is convenient, I'm not.
We'll do that on the next day.
Very well.
Because if Mr. Bachawat says
Very
something, you can add that to your.
Very.
You'll also have to. You can reply to that. Also,
Yes.
if you want.
So
very well. On the prayer of the respondent number 1, the matter is adjourned till July 22, 2026, when it will be listed at the top of the hearing list. For sub next para, learned counsel for the parties are requested to file the written notes of arguments and advance brief oral arguments, if any, on the returnable date.
Grateful. I'm grateful.
Thanks.
Come with your notes. Written notes.
পাঠাডি থাকবে পাঠাডের মধ্যে উপরে ব্যাকের টপ বলে প্রথমে এটা নিয়ে তারপর বাকি সব
So the written notes wants us to exchange give it.
Yes, we are not,
we'll get it here and then submit it.
We'll exchange here.
we don't
We can submit it on that day and give it to the copy to them on that on 22nd.
give a copy previously because they'll also give a
Very-
copy
very
because
good.
Mr.
Very-
Bachawat what he will be arguing we don't.
Very well. Because I've already made my arguments. Very well.
Yes, you have made your arguments.
Very well. We'll do that. Take a 21st date. We'll do that.
Very good. What?
In this matter, I am appealing for the respondent. Kumkum Kormukar.
Moon Karmakar.
I am only playing some time by
No,
now,
no.
because
In appeal hearing, no time.
appeal hearing
This is the
Very
first
good.
appeal hearing.
yesterday we have received the
No, you should not have taken the brief then. Somebody was appearing. No. We can't give further time. Sorry, you have to argue whatever. Why did you accept the brief then? You know it's pending in the list for quite long. It was being argued by someone else. In the midst of argument, why do you take the brief from another person? It's not done. We don't permit that generally. Somebody was arguing already. So why do you take a matter in the middle of hearing? And this is the first hearing matter. Just because you have got taken the brief tomorrow, we are not obliged by that. Please make your arguments or we'll close your arguments. Sorry.
after recess, madam.
Yes, make your arguments. We won't grant time. A judgment was cited. We considerably heard the matter. You had to take, both of you had to take instructions as to what would be the appropriate amount of permanent alimony. Only that. We strongly deprecate this practice of changing advocates in the middle of hearing. And when court expressed its opinion, we heard it, judgment was cited. Why did you take the brief in the middle of a hearing, sir? You're quite experienced. You should not have done it. What will the juniors learn? You have taken a brief during middle of hearing. We were hearing, we heard learned counsel. We opened up our mind. We just ask you to come back with the instruction as to what would be the appropriate amount of permanent alimony. Sorry, we won't grant any adjournment. You inform us what is the appropriate amount.
Yeah.
You are for the appellant.
Recently,
That's your problem, sir, not our problem. Not their
it will be
problem.
taken up after research, my lord.
We had directed you to come prepared with what is the amount of permanent alimony to which you will agree. Tell us.
Your client is there.
Client তো আছে। এখন কি বলবো?
And we have also given a decision. We indicated to your counsel, to the council. Why did you take the brief? The previous council was informed as to we will rely on a judgment, and then you change advocates. And you have readily accepted the brief, knowing that it is appearing in the list. Have you seen even the previous day's order, sir?
No.
Why did you take the brief then? This is very sharp practice. Sorry.
Then take it up with it.
2 p.m. What will you do? You will come prepared on the judgment of Supreme Court. You have given a judgment that's written in the previous order.
Only these two.
Don't make faces. I mean, we are not kind to people who resort to this sort of practices. Your client's conduct is very deplorable. In the middle of arguments, you have given a judgment. We have asked you to come prepared on this and to come prepared on what amount of permanent alimony, because we are dead against you. Sorry, we'll close arguments. You argue right now. You argue right now.
I cannot. At present, my client is accepting rupees 20,000.
We are not. We know what your client is accepting at present. We asked you to come prepared on what amount of permanent alimony you would be agreeing to. If you don't agree to an amount, then very well, we'll not grant any permanent alimony. We'll just dismiss the appeal and then say that we give you liberty to approach the trial court under Section 25. Do that. You won't get any permanent alimony from here, because interim alimony stops the moment we decide this appeal. And we have heard you at length. We asked you to come prepared on Raman versus Kavita. We have given the judgment of our own to your counsel. But you have not come prepared. You have not seen the previous day's order also. An adjournment is sought by learned counsel for the appellant on the ground that he is appearing on change. Full stop. However, comma, the matter has been heard at length previously and the appellant was represented by a different set of counsel. Full stop. Next para. From in the order dated July 9, 2026, passed in the appeal, comma, we had categorically recorded that the learned advocate for the appellant was apprised that the court may take into consideration the decision of Rakesh Raman versus Kavita, reported at 2023-17 SCC 433, while deciding the appeal, and invited the appellant to argue on the proposition laid down therein. Full stop. Merely to enable learned counsel for the appellant to come prepared on the said judgment and to conclude their arguments, comma, the matter was adjourned till today. Full stop. Learned counsel for the parties were also requested to take instructions from their clients regarding what would be an appropriate amount of permanent alimony in the event the divorce decree is sustained. Full stop. Next para. We also record that during such arguments, comma, the court had made its mind clear as to the probable outcome of the appeal, comma, which prompted us to request learned counsel to take instructions on permanent alimony. Full stop. Next para. The change of counsel during the thick of arguments, comma, that too, comma, after the court expressed its mind and the appellant had almost concluded its arguments, comma, such change of counsel is deplorable and is considered by this court to be a sharp practice. Full stop. Next para. However, comma, in order to do justice to the parties, comma, a day apostrophe's accommodation is granted to the appellant and the matter will be taken up on the next hearing date, that is on July 16, 2026 positively. Full stop. Next para. It is made clear that the court shall not commence a de novo argument on the part of the appellant, but shall restrict itself only to the response of the appellant to the judgment referred to above, and as to the instructions of learned counsel for the appellant as to the as to the amount of permanent alimony with which the appellant would be satisfied. Full learned counsel for the respondent shall also take instructions as to how much the respondent can pay by way of permanent alimony, comma, if any. Full next para. It is made amply clear that no further adjournment will be granted to either of the party on the next date. Next date যেটা বললাম ওটা 22nd 15 না 22nd.
At the top, my friend. At the top of the
It
list.
is already appearing at the top.
Fine.
Yes.
May I just apologize but for not being
No
there in a
question of
parted
it.
matter.
Why should I? Yes.
Should have been there in a parted matter.
No, no.
This took place sometime on my lord on 28 January 7, 2007. 28 January 2007.
Right.
And my lord, virtually she left me
Hindu Marriage Act?
in the marriage. And my lord, she left me on.
Can you just please help in with the microphone a bit?
And my lord, she had left my residence, my lord, only on 24/3/2007. We lived together almost, my lord, 2 months. To be specific, 57 days, 6 days.
24/3.
24 March.
Very good.
57. Now, my lord, unfortunately, my lord, we could not live together as husband and wife because the wife had some mental problem and also had some gynecological problems. So, no child. And we have no issue. Thereafter, my lord, finding no other alternative, I had to come up with an application, a suit for dissolution of marriage. And my lord, that was unfortunately, the suit was filed on 13th April 2007, and my lord, judgment was delivered on 30th April 22. My lord,
filed on 13th April?
13th April 2007.
Achha.
And my lord, the judgment was delivered on 30th April 2022. And during this long period, my lord, we did not live together. I was made to pay her 15,000 alimony per month. Till date, my lord, I have paid her, my lord, about 21 lakhs. Now, my lord, the position.
Even after the decree, you have been paying?
Right from that.
No, after the decree also, you have continued
Yes,
to pay?
yes. Till date, my lord, it is my obligation. I have to take care of her. So, my lord, unfortunately, my lord, this is during my long careers, my lord. This is the second time, my lord, I am appearing on behalf of the husband. Well, I never appear on behalf of the husband because I have the feeling that they are the oppressed lot, rightly or wrongly, my lord. My lord, only in one occasion, my lord, long back, my lord, there was a marriage between the husband was a Bagdi and the wife was a Brahmin. There was the love marriage. Therefore, we are told the unequal combination is always bad. Osama Milon Kokono. This is scripture say.
Yes.
Then, my lord, you had ultimately, my lord, unfortunately, the lady died. And my lord, that case was taken up, and she died of cholera. It was there. Then, my lord, the husband was imprisoned, Bakura case from Bakura, 10 years. And there, my lord, I was approached by a very responsible person to take care. Only thing, my lord, that she has got the right to appeal. So I obtained, just appeal was admitted and have to bail for it. And there I was told that we loved, used to love each other. And my lord, in Statesman, my lord, on Sunday, there's a, what is the love? Love ill, loss of woe, O ocean of tears, V valley of death, E end of life. And this is the life. And unfortunately, then this is the second time, my lord. Why I have taken up the, I have seen that, my lord, the husband, my lord, is really unfortunate, my lord.
Why was the suit dismissed? On what?
My lord, should you know, my lord, kindly come to my lord page. Kindly come. Kindly come to the page. The judgment decree, my lord, 64. Kindly come to page 64.
Yes. Yes.
My lord, I do not want to waste your lordship's time. Kindly have a cursory glance of judgment. না আমি পড়বো না দরকার দেখি
So the court records that it was your grounds were one, nullity because of no consummation due to her willful
and cruelty. Nothing else.
And cruelty, but desertion is also written here. Desertion could not be within. So
only thing is, my lord, cruelty, and we could not live together as husband and wife. Now, my lord, my sins, my lord, right from 2007, and today 26th, just July. My lord, we could not live together. What is the use of my lord? Is there any marriage? Well, for the ends of justice and fair play, since there is no love lost between the husband and wife, what is the use of? Well,
Have you brought the judgment, Rakesh Raman?
Yes, yes. Well, I am relying on three judgments, my lord.
Amar Ghosh, Rakesh Raman,
Naran, my lord, unreported judgment one. That is.
You are appearing for the other side. No, even on a different matter. Yes. So.
My lord, one thing is this, my lord.
Yes.
My lord.
But you could not prove the non-consummation. It's very difficult to prove, obviously. Yes.
Well, the only thing is this, my lord. The fact remains, my lord. I do not want to go into details. She was a psychiatric patient.
Could you prove that?
Yes. My lord, only thing is that
you also could not prove that.
No, evidence is there, my lord. Evidence is there. I'm. Yes, my lord. My lord,
that is not dealt with.
My lord.
That is not. Issue number 3. Let us see how it has been dealt with.
Yeah. Now, my lord, kindly come to my lord. Running page, my lord, 41. I will read it, my lord. So the running page 41. Kindly come to the 41. Running page of 41. Para 16. Running 41, para 16. That on 24/3/2007, your petitioner forcibly took his wife to Dr. Satyabrat Kaur. And this is, my lord, I am reading from, this is 38 Epidemic in Chief.
Your affidavit.
Yes, Epidemic in Chief.
It was not expertise.
No.
Right.
And on 24/3, kindly, my relevant
24/3, yes, para 16.
On 24/3/2007, your petitioner forcibly took his wife to Dr. Satyabrat Kaur, psychiatrist, for a treatment. At the time of consultation with the said doctor, suddenly the respondent took out a prescription from her purse and handed over to doctor, who showed that she was a patient of Dr. Borun Kumar Sinha, gynecologist, for 7 to 8 years and took medicines for a long time. Then, my lord, kindly come to, my lord, page 46, running page 46. Page 46, my lord.
Yes.
Yes, my lord, page 46. From the bottom, second, last line from the bottom.
Yes.
I did not file, your lordship has got it. I did not file any medical document in there. No original document lying with me, but I have Xerox copies of some document. My lord, original document was lying with her. My lord, and my lord, I have submitted, my lord, Xerox copies of the Yes, page. And my lord, here kindly have it.
We cannot look into the Xerox copies because that was.
My only thing is this: I wanted to impress upon your lordship. The fact remains that I had not the original document, so I finished, my lord. I submitted it. Now the point is, my lord. Then, my lord, kindly come to, my lord.
There are two aspects of the matter against you. Yeah. One is that your para 16 is very vague as to exactly what disorder or illness she had.
Yes.
So gynecological problem may mean many.
No, my lord, specifically the prescription will show that she had.
You cannot look into the prescription. That is the difficulty. You did not produce. If you could have produced a secondary evidence by satisfying the.
Yes, my lord.
It was not exhibited at all.
My lord, only thing is this, my lord. Original was lying with her, my lord. Original,
yes, that explanation could have been given in your. You know better.
My lord,
could have been given, and you could have.
Since he has admitted that document is lying with her, my lord, this can be treated as secondary evidence.
Could be, yes, but you did not take that step.
Yes, my lord, only thing, my lord, your lordship can tell me, my lord, so far as
you cannot look into it. No,
my lord, only thing is this, my lord. Why I am on, my lord? I mean, under order 14 rule, order 11 rule 14, my lord. And,
order 41 rule 27. Order 41 rule 27.
27, my lord. I mean, I cannot take steps, my lord.
No, that is not used to fill up lacuna of the parties.
No, my lord, only thing is this, my lord.
You failed to produce a
No, my lord, only thing is this.
It's your case.
My only thing is that.
And your case is very vague. She was a patient of a gynecologist for 7-8 years.
Yes.
Several
No,
problems.
No, I'm not on that gynecological problems. She was also mental patient. No, she did not cooperate to live with
Where is
us.
the proof? Where is the
Yes, my
allegation?
lord. In the prescripts,